My pleasure, Lordship, madam. Madam, I may be accommodated, madam. I have taken the consent of senior advocate Mr. G. Majumdar.
Which matter?
Item number 20. I am not keeping well today, madam. Lordship, can you accommodate me fixing the matter?
You have a petition or
I am the appellant.
appellant?
Yes, ma'am.
Mr. Prakash, the learned counsel for the appellant with consent from the other side as for listening the matter after
After, madam, on Lordship, can you fix the matter on 3rd of June?
3rd of June.
3rd of June.
3rd of June. Okay.
Obliged.
May it please the Lordship, I beg to mention item number 27. With the consent of the other side, Lordship may kindly be pleased to adjourn the matter for the day.
Mr.
D. Rathi.
Learned counsel for the appellant with consent from the other side price for adjournment of the matter for the day. Accordingly, per law, the matter is then adjourned for the day.
Lordship,
Yes.
if it can be fixed on 5th June. 5th of June. Okay. Much obliged, madam.
Lordship, on RSC matter and on the RFA matter, I pray for early hearing.
Take a date from him.
On 3rd and 5th, one on 3rd, one on 5th.
Mr.
No.
Bora?
No, with the consent of, on item number 1, my lord, Lordship had called for the records. I could not lay hands on the records, my lord. If Lordship can fix it on 3rd of June, my lord, because the records are coming from 2 places, one from the school, one from the director office, my lord.
Okay.
2 records are to be done. On 3rd of June, my lord, item 1.
Mr. Bora, learned standing counsel for the BTC with consent from the other side price for listing the matter after
3rd of June, my lord,
on 3rd of June.
3rd of June, my lord.
3rd of June. Per law.
3rd,
Then, my lord, this is a part matter, my lord,
It's a pardon matter, my lord.
or 5th, my lord.
No, then next week.
My lord, if record may not come, that's the, I am taking it a bit long, my lord.
10th June, 10th June,
10th.
after 1 week.
My lord, 10 June, my lord. Obliged.
May I please, Lordship? For the listing of the case, Your Lordship, this was listed on RSA for hearing.
Hmm.
This was listed on 4/4/2005. And the matter has been fixed for the first week of May, but till date, it has not been listed, Your Lordship.
When do you
So-
want?
29/5.
29?
29.
May I please? My lord, I have filed in CFM 94 of 2005 on 1st May, my lord. And I has been numbered as 1431 of 2025. But till yet matter has been not listed. Finally,
Okay.
taken up Friday
Okay.
of last
This Friday?
Easter.
No, no.
My lord,
Next week.
on
On
1st
Monday,
May, I have filed mine.
on Monday, 26th.
Of last.
May it please the Lordship, Lordship, with the consent of the other side, I beg to mention item number 14, Lordship. Matter may finally adjourn, Lordship. 1/4.
Lordship, when you fix the date, Lordship, item number 14,
After,
I'm on the respondent number 2.
after 20th June,
You are for?
I'm for the appellant, Lordship.
Miss?
I'm Nirola, Lordship.
M. Nirola, learned counsel for the appellant with consent from the other side price for listing the matter on
Any date after 20th of June.
24th June.
Obliged, Lordship.
May I please your Lordship. My lord, I beg to mention for listing MSc appeal, my lord, may be taken up in 12th June, my lord. Hearing matter,
on?
12th June,
Okay.
early of last, your Lordship.
May it please your Lordship, Lordship, with the consent of the other side, I beg to mention item number 11 and 12. Lordship, matter may be adjourned for the day.
Well, they both the cases already, one of the case already passed by the Lordship, my lord, in favor of the railway granting the appropriate directions, my lord.
Mm.
Now they are filing review petition against the judgment passed by this honorable court, my lord.
Mm.
So then that's why they are seeking time, my lord.
Okay.
This is covered by the decision of this honorable court passed in MFA number 2027 of 2016.
Mm.
Covered by the both the cases. Now they are filing the against the judgment dated 10 to 2025, passed in MFA 27 of 2016. They filed a review petition.
Okay, all right. When do you want?
But the review petition may be listed on the 12th June, my lord, along with
June.
this. Yes.
Miss?
M. Kolita.
M. Colita, learned counsel for the appellant with concern. No.
I am
This
for
is
the
appeal.
appellants, my lord, both the
I'm for the
cases.
respondent.
I am for the appellants, both the cases.
Learned counsel for the respondent with concern from the other side, pays for listing the matter on 12th of June.
12th June, along, my lord, both the cases will be listed along with the review petition number 63 of 2025.
Okay, along with the review petition number
63 of 2025.
63 of 2025, filed by
Respondent.
Yes.
respondent. Okay.
Obliged.
Obliged, your lordship.
May I please, Your Lordship? Lordship, I pray for listing of a LA appeal, Lordship, tomorrow, Lordship. Lordship, the appeal is against the judgment and order of the learned districts and session judge, Lordship, granting compensation to the government of, to pay compensation by the government of India, Union of India, Lordship. So, and the execution case has been filed, Lordship. So, Lordship, this is an urgent matter, Lordship. I have filed through e-filing, and today we will get the Lordship, the physical filing number, Lordship.
Tomorrow,
For tomorrow, Lordship.
40 plus.
Tomorrow, lot of matters have already been fixed. Day after tomorrow.
Yes, definitely. So I'll provide the filing number
22nd.
in the due course.
Yes, Mr. Talukdar.
My lord, in item number 2, we have filed our affidavit that may be called for, my lord.
Okay. When did you file?
Yesterday.
Yesterday. Yes, Mr. Soliha.
Yes, Lordship, I beg to mention item 23 and 24 of today's list. Lordship, this matter came up for consideration yesterday, whereby the education had sent a proposal to the finance department, Lordship.
Yes.
Lordship, here the department has communicated that they had received the communication on 17th
Hmm.
and it is under consideration. Lordship, they are just asking for 10 days time to process the claim of the petitioner, Lordship. 10 days time may be granted to us.
Why 10 days is necessary?
No, Lordship, because we had received it on 17th, that is yesterday, and that is Saturday, and it was closed. Now it is under Lordship, 10 days time to verify and pass the
No,
necessary.
what to verify? The judicial department has already given its opinion
Yes, Lordship.
favoring the petitioner.
Lordship, then I pray
Then
for
what
one.
to check it?
Yes,
What
Lordship.
remains to check it?
Yes, Lordship. No, Lordship, only verification, only to process the
No,
file.
1 week time.
Lordship.
Lordship may kindly fix a date next week, Lordship.
Okay.
Lordship, 1 week time.
Eid festival is also there. I am waiting since January 2024, Lordship.
Then Lordship may fix it next week, Lordship. I'll inform the department, Lordship, and to expedite the process, Lordship.
And,
Mr. Soliha, learned standing counsel for the finance department with a consent from the petitioner, press for listing the matter on
Next week, Lordship.
Next.
Third meeting. 28.
28.
Lordship.
The matter stands released from the party.
Lordship may not be released, Lordship.
Why? No, next week, this court will not be sitting here.
Then Lordship may Lordship may not be released from Partha. Lordship maybe a date may be fixed as per this honorable schedule of this honorable court, Lordship.
On 9th June.
Lordship, there is every possibility that we'll give the concurrence before 9th also. So Lordship may fix it on 9th. The department will do its job, Lordship. So if
Okay, 9th.
Lordship, one thing may be made clear, Lordship. Earlier also they have received proposal and returned it back. And since in this way we are suffering, so Lordship,
No, Lordship, now the
taking
queries have been
instructions
made,
is long. So that may kindly be clarified, Lordship. Otherwise, they may again come with say that we have returned the file. Because earlier also told.
Let us see, in the meantime, they have already obtained the
Lordship.
views of judicial
Yes, Lordship.
department.
Lordship, there is an interim order that may be extended, Lordship.
Oh, interim order plus earlier shall come.
Lordship, till disposal of the, otherwise we have to again and again.
Okay, till disposal of the writ petition.
Lordship.
May it please, Your Lordship.
Mm.
Item number 5, my lord. Can it be taken up at 2, my lord? Item number 5.
My lord, here I have also some submission, my lord. Here, lordship may kindly take all the bail matters at 2, my lord. 5, 6, 22, 25 and 26, my lord. Due to the blockage of watermelon, PP is not coming at time.
Okay, we'll take it up as a last item.
Minor.
Last item.
Minor. All the minor. Obliged.
And one more prayer, my lord, prayer for listing of an RSA, my lord, order 41 hearing, my lord. Can it be taken up today, tomorrow, my lord? Urgency is there, my lord.
Tomorrow not,
Executing court is already proceeding.
this week not possible.
Not possible.
Next week. Next week, any day.
Highly.
Next week, any.
Yes,
Please, your lordship, I beg to mention RSA 17,030. Your lordship may kindly fix the matter on 27th, 27.
7th. For hearing,
For hearing. On 29, 27, we have many cases. On 29. For admission, item number 3.
you have sent the council. No,
I have not seen him yet. I'll make a call, my lord.
okay. After some time.
Much obliged.
Number 4.
Chief, kindly pass over about timing,
Pardon?
timing.
Time being. Why?
Senior, VP was code number 1, election, lordship.
Who is your senior?
VP Bora, lordship.
Okay.
Lordship, the matter may be taken up at 12 then.
12
At 12, Lordship.
today.
Today,
Okay, as the last item, not as at 12.
Lordship.
Look.
By order 7.
Hmm. 7 and 8 for orders.
Lordship, under the instruction of Advocate General Meghalaya, they have not yet engaged an advocate for Forest Department. The earlier advocate, he has resigned. So 4 weeks time may be allowed to appoint new advocate.
This application is filed by you.
No, no,
IA?
no. The IA is filed by the private party for vacating a IA application which is already disposed of.
Pardon?
I have filed an IA
Hmm.
for staying of the operation of the impugned order.
Hmm.
That IA has been disposed of. They have filed this IA to vacate that order. Actually, they would have filed an appeal. My IA has been disposed.
Okay, but the counsel for the applicant is absent. We'll take it up after some time.
Okay.
Go ahead.
For hearing, item 9.
Lordship, matter will be taken after some times.
Why?
May I please, Lordship, my senior UV Sharma for appellant could not arrive till at court due to water logging.
Okay, then after some time. After some time.
Yes. Master.
Number 10.
Lordship, on the last occasion, your Lordship has almost heard this matter.
Mm.
This is pertaining to Lordship as to whether the petitioner is entitled for UGC scale of pay with effect from 12/11/1993, that is from his date of appointment, or instead of August 2009, when I have passed my PhD. That was the Lordship, some similarly situated persons. They have been given the regular UGC scale of pay from their date of regularization. But I have been deprived.
You have not been given from the date of regularization.
Regularization.
From that, you have been given from the date of
I have been given from Lordship August 2009.
August 2009.
Lordship. My claim is with, I should be given with effect from 12/11/1993.
No, you have obtained a PhD on
Lordship, I'm sorry, Lordship. This matter has been allocated to Mr. D. Upamanyu because of some personal difficulty. He would not come, Lordship. Last now I have come to know, Lordship.
Hmm.
So, Lordship, may matter may take now on another date, Lordship. May I pay?
other day.
Or tomorrow, Lordship.
Lordship, in fact, Lordship, your Lordship has heard the matter, and one more matter was analogous, Lordship, that has already been disposed of. And during the midst of hearing, Lordship, my learned friend asked for filing an additional affidavit, Lordship. That has also not been filed.
Actually, I am
Lordship,
not
may
aware-
kindly see the last order, Lordship.
Yes, you were supposed to file an affidavit.
Yes, I am not aware about the matter, Lordship. Just now I have been informed. Next,
You will also obtain instruction whether the affidavit is ready or not.
yes,
You inform this court just now, right now.
whether he is affidavit is ready.
Yes, yes.
Yes, Lordship.
And Lordship, for a moment, Lordship, if your Lordship sees the order as a 21/3/2024, there is already an observation by this honorable court, Lordship. Lordship may kindly see the order as a 21/3/2024.
21/3.
2024.
Well, let us see.
Lordship.
I am for item number 12, my lord. I came to know that matter has been mentioned, but I have not given any consent to the learned counsel of the respondent. That may kindly be upgraded, my lord. Item number 12. On every occasion, my lord, they are praying for time. And this time, I have
This is
not
a tag matter with item number
12, my lord.
12.
Yes, my lord. That may kindly be upgraded, my lord. Next date is fixed on 12 June.
Yes.
That may kindly be updated, my lord. If
You obtain
I
consent from the other
I was
side.
not informed by the learned counsel of the respondent who has
No,
mentioned.
behind their back, we will not upgrade it.
Yes, my lord.
They have also filed on review petition.
Yes.
On that day, it is directed to take on to put up the matter, put up the review petition also.
My lord. Obliged.
Instruction is there, he has received and lordship affidavit is there. Yes, lordship, he has got the instruction, lordship. So lordship, maybe matter may kindly be taken up on 5 days.
Not present today, Malad, due to some medical urgency, Malad, he is not present today. And this, since matter is part heard, Malad, the file is also with him. Malad, as per instruction, he has prepared the affidavit, and I think it will come. It went for waiting, Malad. The signed copy will be received by today.
Okay, let it be on Friday then.
Yes, yes.
Huh? Heard Mr. SK Das, learned for the petitioner. And also heard Mr. S. Das, learned sending counsel for the
Higher education.
Higher Education Department. Mr. Das submits that this matter is being looked after by Mr. Opomunya, and for some personal difficulties, so he could not remain present in the court. And as per his instruction, the affidavit is ready. And the matter may be listed on Friday. Accordingly, it is provided that let's list the matter on Friday. As per heard.
Much obliged.
Obliged. 13.
None appears for the petitioner appellant on call. List the matter after 1 week.
Item 15.
Okay. None appears for the appellant on call. List the matter after
16.
May I please your lordship? Your lordship, I am appeared for the insurance company. Insurance company has a prayer to list the matter in the next Lok Adalat since the appeal is filed for enhancements of compensation.
none appears for the appellant on call. However, Miss
You Roy,
Roy learned counsel for the
insurance company.
insurance company. Respondent number 1 submits that the matter may be listed in the next Lok Adalat. When it will be held?
As per my knowledge, it is on 14 June.
14 June.
14 June, I guess.
Accordingly, it is provided that Registrar shall list the matter in the next Lok Adalat. And Mr. Roy shall inform the appellant if possible.
17, 18.
May I plead the lordship? Lordship, may your lordship grant pass over the time being, as my senior has not arrived till now.
Well, not for the time being, my lord. I have some difficulty, my lord. Second half, I've got an appointment with the doctor.
So lordship, your lordship, after 1 hour after half an hour he'll arrive, your lordship.
Difficult.
After half an hour he'll arrive, your
Next week,
lordship.
my lord, I'll do it. No problem, my lord. Next week, my lord. Some
Next.
difficult, because I'm suffering from some medical difficulty, my lord.
So at least half an hour, your lordship. My senior
It
will
will
appear
not be
after half an hour.
completed in even 2 hours, my lord, time. It's a complicated matter. There are 2 appeals.
Okay. Mr. Sharma, learned counsel for the respondent.
Tell me.
Submits that the matter may be taken up on some other day. As he has some personal difficulties today. That is accordingly allowed. Registrar is the matter on
Any day in the next week. For
next
the-
29th.
Good.
Mr. Your good name, please.
Your lordship, N. Bhuya,
And we are learned counsel for the
appellant, your lordship.
appellant present.
Your lordship.
Item 19.
19 to adjournment. RFA. 19 adjourn.
19.
None appears for the appellant on call. List the matter after 1 week.
21.
None appears for the appellant on call. List the matter after 1 week.
28.
Lordship, item 21.
21.
You are for?
I'm respondent here.
Learned place for the Mr.
B Kumar.
For learned counsel for the respondent present. Place the matter after 1 week.
Lordship may kindly fix the date because there is a stay in this matter. Right.
28.
Lordship, can this matter be taken up after some time? Council is on leagues in other court, your lordship.
Okay.
Okay.
Lordship, both of us were found absent, item number 15.
After 1 week. Are you ready to argue the matter?
My lord?
Are you ready?
Yes, my lord.
Mr.
Lordship, in fact, the respondent has passed away. They have filed a close title also. And there
Wait.
was a talk of compromise going on between the parties. And a compromise deed was also entered into by the appellants and the respondent. However, before any order from this court, the respondent passed away. Under such circumstances, there was a compromise already.
Cross title, substitution has already been done. Our submission is that if it is considering to the family matter, if it is sent back, they will decide it locally there in that lower court, or if the court so desires may pass any order which fits. Since the family matter and as per the judgment of the court below, they have already compromised and filed joint petition here.
So the partition suit, Lordship, basically the
156 RFA. Partition suit.
Partition was granted and against that this appeal was preferred. During the pendency of the appeal, they entered into a settlement, Your Lordship, family understanding.
Whether any document in respect of the settlement is filed before this court?
Yes, my lord.
It is.
Joint petition is filed.
But immediately thereafter, the respondent passed away. I don't have any instruction regarding that as per what will be the stand of the legal aid.
But date will come. Judgment of court.
The legal aid is a minor. Minor son.
This appeal is preferred against the judgment and decree passed by the Lord Civil Judge Boingao on 16th of July 2018. And both sides agreed to this decree, judgment and decree. Both sides.
No, Lordship, there was a settlement deed which is separate from the terms of the decree.
As per the judgment, but this partition was shown and given, and that against that we came, but then thereafter, the both parties sat together and
Where is
we
that
joined-
that settlement did at page number? Have you furnished the settlement deed before the court?
Yes, my lord. Yeah,
When?
my lord. Get a registration.
Settlement deed already, yeah. Have you filed it?
Yes, my lord, just try to locate it, find it.
Amended.
Some pieces, it so thank you. I think, okay.
So in terms of this settlement, did we will dispose of the matter then?
Yes, my lord, that was the year, but then the respondent in the meantime, the expired. The cost title is.
Amended,
Yes,
already amended.
Hey. So if your lordship passes the order as per the agreement, this is allowed, then your lordship may pass the order.
So in terms of the settlement, as mentioned in this petition.
Yes.
Heard Mr. Soria, learned counsel for the appellant, and also heard Mr. Mukherjee, learned counsel for the respondent. Person to order dated 21st of April 2025. Mr. Soria, learned counsel for the appellant, has filed amended cost item. Mr. Soria, learned counsel for the appellant, submits that the respondent herein as plaintiff filed a title suit number 02 of 2015 in the Court of Learned Civil Judge Boyega against the appellant struck defendant for declaration, partition, eviction and cast position. Then by judgment and order, judgment and decree dated 16/7/2018, a preliminary decree is granted in favor of the respondent, stroke plaintiff, to effect the partition. Being aggrieved by the aforesaid judgment and decree dated 16/7/2018, passed by the learned civil judge Moyano, the appellant herein before this present appeal. And during the pendency of this appeal, the dispute between the parties have been settled amicably with the help of their families, near relatives, and well-wishers. And to that effect, both the parties have signed one agreement, filed one memorandum of understanding dated 12/1/2024. Where is that memorandum of understanding?
Filed on 19/1/24. 25.
This is not part of this petition. Furnish a copy if as per the aforesaid memorandum of understanding dated 12/1/2024, the parties have agreed on the following terms and conditions to settle this RFA number 156 of 2018. 5 terms are there. Yes. Mr. Mukherjee submits that the respondent herein has no objection in the event of disposing of the matter in view of the terms and conditions as settled by the parties in the memorandum of understanding dated 12/1/2024. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is inclined to dispose of this RFA in terms of the settlement arrived at by the parties in as set out in the memorandum of understanding dated 12/1/2024. This is original copy you filed on a Xerox copy.
Original will be written on the record, with the record that they have submitted.
Original. Okay. Mr. Sohoria, learned counsel for the appellant, has furnished the original deed of settlement before this court. And the same shall be part of the record. In terms of this RFA instance, dispose of.
Obliged.
May it please the lordship. My lord, on the last occasion during the course of argument, one query had fallen from this honorable court that whether this case of the student, my lord will remember this case.
Yes.
So whether it can, my lord, I have spoken to the IIT people and they have understood. Only thing is this, my written instructions are printed, but I have got the oral instructions are there with me. It is this that, my lord, if he can be considered, my lord, in the Senate meeting which is upcoming, in the Senate meeting of in the month of July, it can be considered. His case, if it will be little helpful for his case also, he makes a proper application and states his facts and something, they can, the highest body is the Senate, my lord. So they can, in their meeting, they will look into the entire record and they will pass an appropriate order accordingly. My lord can,
Appropriate means a favorable order.
my lord, I will, my lord, I will try to communicate the feeling, my lord, but they will, because my lord, that cannot be now, as in on the writing, my lord.
Mr. Subrata, you see, we have no problem in adjudicating the dispute.
My
But
lord.
we want to settle the matter amicably.
That is the reason, my lord.
Yes,
That
so
is,
then.
if he agrees to make to remand that way back, my lord, then my lord will give a direction. Agree to this, because it is basically remanding back the matter, my lord, for a fresh consideration. So they can take a decision and then my lord can. Yeah.
Okay, you file an application then, representation there.
I will do that, my lord. Lordship may keep it pending in that case, because otherwise, again, if by chance it goes against us, again, we have to come and file a fresh petition and affidavit in opposition and all it will be there.
That, my lord, I will leave it to his ear. But what I do not see personally, my lord, there is any inhibition should be there. Because if he wants to pursue his PhD program, he must say in very clear terms that this is what I want to do. Within this much time, I will be finishing up. If he sees and desist from his activities, I do not think that IIT will not. Why IIT should not give him an opportunity? Ideally, I am not speaking under instructions, but this is my personal feeling, because the record shows that there were certain amount of activity on his.
Maybe
Yes, my lord.
sort of
So
absurd
this
here
my lord
on his
can
part.
that way can close it, and the decisions can be taken by the authority. I have emphasized, my lord, what is and they have also understood. If he is ready to abide by the conditions, I think they will be taking an appropriate view. Only thing is this, that
Sir, I will approach, my lord. I will do that definitely. Just that, my lord, I'm apprehensive that some conditions may be fulfilled, imposed on us, for which we may have to come back. That is why I'm only requesting that the matter may be kept pending. If we settle the matter outside court, lordship will close it anyway, my lord.
what conditions can be, my lord? Conditions can be.
Already spent
6
several years.
Yes, my lord, 6 years. 6 years outside the
If
PhD.
again you are contemplating to
To
take
litigation.
another 6 years, then
No, my lord, I do not
detrimental to the
want that.
authority.
If they take
In
me
that
back, my lord,
matter,
I will.
they may want the undertaking from you that you have to complete the entire
Earliest
within a stipulated
period of time.
That is in my interest, my lord, because for job applications also, the sooner I finish, the better, my lord.
My lord will keep it in open-ended, my lord, because this is between not councils and councils, this is between the student and the authority, my lord. Because they has to understand each other's requirement, how far his PhD program has pursued, what stage he is in. This, my lord, will keep it open-ended, because this will not benefit at least
any of the party.
Any of the party, my lord. My lord, I will submit, my lord. My lord may close it if my lord feels it that way. No point in keeping it pending unnecessarily. So I also, my lord, has not seen anything which is not. He is also saying that he wants to do it, whatever is there. That can be, I think, done, my lord, provided there is an honest effort from both sides, my lord. I will instruct my client also properly. I've done that. That is the reason they have also agreed to look into this matter again, making him applications and all that.
Can you do one thing? You place on record the instruction you have received.
My lord will, that will be, my lord, will be easier for me also.
Yes. Yes.
The director is actually, my lord, out of his, there is a marriage in his own son's marriage. So
Okay, that's all right. We will fix a short date.
short date, my lord. Next week, my lord, I'll place the written instructions, my lord. It will be easier for me also, my lord.
Okay. In the meantime, he may file an application.
Application,
for the
yes.
I will file. I will file it.
Heard Mr. Day, learned counsel for the application, and Mr. Subrata.
Mr. A.B. Day, my lord. A.B. Day.
A.B. Day.
Yes, ma'am.
Sorry. A.B. Day, learned counsel, appearing on behalf of Mr.
For the IIT, my lord. 1 to 3.
Appearing on behalf of Mr.
AP 1, 2, 3, respondent number 1, 2, and 3.
Respondent number 1, 2, 3.
My lord.
1, 2, 3. Mr. Sutradhar submits that. Okay.
Mr. De, my lord, will.
Okay. Mr. Sutradhar submits that person to verbal instruction of this court. He has obtained instruction from the respondent IIT, and he will place the same on records. And press for granting him some time. There is accordingly allowed. Recessal is the matter
On 27th,
27.
my lord.
Okay. Okay.
Deeply.
Much obliged.
My lord will record by this time he will make an application, my lord, by this time.
Not necessary.
Not necessary.
But I have the liberty to file the application.
Let him file the application, my lord. It will be easier also.
Okay. In the meantime, Mr. Day, in the meantime, the petitioner shall file an application before the respondent authorities, expressing his willingness to continue with the PhD program.
My lord.
Much obliged.
Timing for
After condemnation of delay, it has come to me, issue notice and call for the still under 299 of the Indian Succession Act for refusing to grant probate.
Heard Mr. B.P. Bora, learned counsel for the appellant. This appeal under section 96 retweet section 299 of the Indian Succession Act is directed against the judgment dated 9/5/2023 passed by the learned additional district judge number 1 Kamrup and Guwahati in that probate title sub number 6 of 2016. Peruse the memo of appeal and the grounds mentioned there. And also peruse the impugned judgment dated 9/5/2023. Admit, issue notice to the respondent.
I am on behalf of respondent, all the respondents.
No.
Item number 4 in
Four. Okay.
I am
All the respondents.
yes, sir.
Issue notice to the respondent returnable in forest. However, no formal notice is required to be issued since Mr.
P. Sharma.
Learned counsel for all the respondent entered appearance and received notice. However, extra requisite copy of the petition been furnished to him during the course of the day. This is a call for the record from the learned trial court. With the matter after 4 weeks. Is there any interim pair here?
Lordship, yes, I pray to stay the judgment.
Any objection?
No, Lordship. Only that,
After
Lordship.
hearing learned advocates of both the parties and also considering the facts and
Only that, Lordship.
The impugned judgment dated 9/5/2023 stands state till disposal of appeal.
Deeply, Lordship.
timing item 7 and 8.
May I please, your lordship?
Yes.
Your lordship, this IA is for vacating the stay order passed by. Whether your lordship will be taking up the matter or not, because order was passed by Dadan Court number 14.
That IA.
No, stay was passed by, and with this I am challenging that order for setting aside the stay.
Court number 14 is available right now. Okay.
Code number 14 is available. As per last order, direction was given by this honorable court that it may be listed before appropriate bench. On last occasion, there was a direction.
In IA, there is no such direction.
Last time it was listed on 22/4. No.
Lordship, on the last day, it was
was
informed that
listed-
the council for forest department had resigned. And they will appoint a new head. The forest department earlier advocate, he has resigned. So 4 weeks, I am praying for 4 weeks time for appointing a new head.
4 weeks.
4 weeks time. Because the main respondent here is the forest department.
Your lordship, on the last occasion also, the advocate for the forest department 6 times to inform his client that to appoint some other advocates. Today they are also with the
On the
similar
last
prayer.
occasion only, it was informed that he has resigned.
Some order has been passed, your lordship. There are 2 analogous appeal, 7 and 8. That appeal has been heard by the Bajaj Alliance, and this was by Forest, Meghalaya. Some order was passed in court number 22. Last time it was listed before 22. Either in the IA or in the main appeal. Main appeal is 321.
IA number 4053.
4053 is my application for vacating the stay order.
In which IA order was passed?
Now, last time it was listed before court number 22. So court number 22 directed that it may be listed before appropriate bench.
You show me the order.
Lordship, IA 20.
Even my learned friend was
2050
also
disposed
present
of.
on that day.
My IA was disposed, our IA was disposed of.
Next stay vacating to already disposed of. Stay was granted.
Okay, you please go to the record and show me the order.
Coming item 28. For hearing. পণ্ডিতক দেখানে This appeal has been filed on a very simple ground, Lordship. It's not a complicated ground.
What is the ground?
Ground, Lordship, that this was a 21-year-old boy. And he was supposed to be a Mason, Lordship. And Lordship, without any evidence to that effect, some minimum evidence, just consider this, it was an accident in the year 2017. And at that point of time, Lordship, it was considered as 12,000 per month. This is my only, even the minimum wages do not support it, Lordship. At that time, it used to be around 6,000, 7,000. That's a notional income. If there's no proof, it should be considered as notional income. Nowadays, it's 10 years have made almost 8 years have made a big difference. But 8 years back, it was on the lower side. 12,000 was a very exaggerate. 21, he may not have developed any experience. For a skilled worker, semi-skilled worker, there are some, Lordship, as one ages becomes older, his skill develops, Lordship. So it's not even, can be at best considered a unskilled, semi-skilled worker.
Mason is a skilled worker.
But then he has to get some experience. He doesn't become a skilled worker overnight. He has to gather some experience. 21 years, he might have just I mean, it's also not proved, Lordship. Whether he was a Mason, that was not proved. Presuming that he was a Mason, Lordship, presuming that he was a Mason. In that case, there has to be a difference between a 40-year-old Mason, 30-year-old Mason, and a 21-year-old Mason. That credit has to be given to experience, the length of experience in the line. So taking it as a straight way, even as a skilled worker, at that point of time, minimum wages do not support it, Lordship.
What was the minimum wage at the?
Lordship, I had just downloaded this part, Lordship, a little bit unclear, but your Lordship may say for that particular period. Every time it is downloaded for that particular time frame. So when I downloaded this time, it was not very clear, but one can still make out. I'll read out. Lordship. This notification is of 7 December 18. It was almost 2 years after the accident, 1 year, 10 months after the accident, Lordship. So even then, this will serve as a guide to the previous notification, Lordship. What was it? In the previous notification, for a semi-skilled worker, Lordship, it was 8,400. Then 2 DAs to be added to it, up to that next 2 DAs, 67.20 and 92.20. So at base, it will come up to 8,600. It changes again after 1/12/17, that is after his death. That will not be applicable. What will be applicable is the first para plus the next 2 for variable DAs. Like, even if we take this as a guide, Lordship, it will be 8,600 at the most. First thing, Lordship, we do not have any evidence of his occupation. Firstly, Lordship, we do not have any evidence as to his occupation income. Now, even if we presume it to be him to be a Mason, at 21 years, it is almost, I think, Lordship, it will be very realistic to consider him as a semi-skilled.
There are some judgment of the Supreme Court that some gives work is permissible here.
Lordship? Lordship, what I'm trying to say, Lordship, is that even if very liberally speaking, Lordship, there must be a difference between a 30-year-old, 40-year-old Mason and a 21-year-old Mason. So you consider slightly lower than that, not that. If the top is skilled, he can be placed immediately joining the profession. If he was a Mason, it can be at the most semi-skilled. Even then, it was higher than the prevailing notion. I can show you, Lordship, even in those times, 8 years back, 8,000 used to have notional income on the higher side. People used to challenge even 8,000 in the High Court, Lordship. So 8,000 at that, we have to think of that time, Lordship. Perception at that point of time. Even at that point, people used to file 8,000 is on the higher side. I have personally been a prosecutor.
Lordship, the judgment is of 6/1/2020, Lordship. So while passing the judgment, Lordship, the Learned Court is well aware of the notification that my learned senior friend is relying upon. And Lordship, if Lordship hears the cross-examinations part of the claimant side, Lordship, it is the insurances failed to dispute regarding the income, Lordship. In the cross-examination, it is clearly stated that it is not a fact, and the claimant has duly proved his income. And Lordship, further, the claimant is also suffering from permanent disability, Lordship, and which is proved by the by calling the doctor as court witness, Lordship. So, to my respectful submission, and Lordship is aware, also there are judgment, Lordship, passed by this honorable court also, wherein, Lordship, the amount which the Learned Court is considered as 12,000, it is justified amount, Lordship.
Also, Lordship shows some in this case. Lordship, I have not got challenged the other aspects of the claim. It was disability, whatever percentage has been considered, I have no dispute with that. Only point is, this is the only point, as I have said, this is the only point, income. So doctor was called or not, that is not my case, Lordship. Except that he has been called and he has duly examined and I have not brought any Lordship dispute about those particular aspects. I am strictly on the point of Lordship income, Lordship. Lordship, I may, Lordship, if your Lordship permits, I may just show some This is the notional income that is to be considered. I will just pass on these two slides. I have prepared from a year. Lordship, it's a verifiable judgments, Lordship. From Guwahati High Court and also Supreme Court. Lordship may see it was notional income. If we consider notional income, there's no proof of income. I don't know what evidence my learned friend would like to show. There's no evidence. Even if someone claims 1 lakh as a thelawala, and wait, I don't challenge it, it has to be on some good basis, Lordship. Even if I don't challenge it or not, it has to be, the court has to be of it. So you may see, I have given various status, his age, income, family members, what are all things, what is date of accident. It's just trying to show, Lordship, that in those times also, various ages, various times, it used to be like that 8,000 was a figure which people used to challenge in those times, Lordship, as being on the higher side. But I'm just saying, even if we take it as, well, also Lordship may see the practicality, 21 years, maybe it's on the exaggerated also. Because people try to show more income and inflate the age without any proof of it. So even he might have just stepped into the, he may not have been working also. 21 years, but he may just consider a practical aspect. Even if he is working, he may not have gathered that much of experience. We have to be realistic about assessment of behavior because anyone might claim, he might claim anything.
At the age
and
of
just
21,
21.
a person can be skilled labor also, skilled mason also,
What
skilled
is-
carpenter also. There is no dispute. There are so many examples also. Here losses goes on and around losses. There are so many persons at the age of 17 and 18. also
People
they become
make
skilled losses in
inventions,
their-
discoveries, but depending on his level of knowledge, skill, etc., that has to be in that particular year. It is, we are not talking of geniuses, Lordship. We are talking of common people. Instead of going by the exceptions, let's go by common rule, Lordship. Exceptions are always there. You have child geniuses at 12, 13. We are not talking of geniuses. We are not talking of exceptional people. We are talking of someone who has not established its credibility. Each and every time an exception cannot be, it's public money. We have to keep that also in mind. Compensation, as is always being said by Supreme Court, cannot be fanciful, excessive. It has to be realistic. I'm saying that 21 years, nothing is established in this case. Even very liberally speaking, that is my ground. One does not become a skilled person like a mason at such a young age of 21. I have said this for 5 years back.
No minimum years have been prescribed to become a mason.
No, I'm not. I'm just giving a realistic, trying to paint a realistic picture. I'm not saying, I'm saying there are always exceptions.
Mr. Goswami, on that realistic picture, we cannot adjudicate the matter.
Lordship, he has not proved his income. First thing, he has not proved his income.
Let
In that
us
case,
say-
we come to the fact of notional income. And I leave it to your Lordship entirely. I'm just trying to show what the courts used to think in those times. By what the Supreme Court used to think, what the High Court used to think. In those times, what is the level of income that was considered by the High Court and the Supreme Court? Even now, Lordship, in Supreme Court, till last year, I have come across judgments where 4,000 has been accepted because it pertained to a long time back. 5,000 is accepted. It's not, they did not judge it by today's standards, Lordship. Their mindset has to go back to those times, Lordship. The time frame has to be kept in mind. This is the only submission, Lordship, I have.
So learned court below has lordship rightly passed the judgment while considering all the grounds what my learned senior friend is stating lordship. Judgments of 2020 lordship and that has been duly discussed in the judgment lordship. The judgment is very clear lordship. So there is in my reference submission lordship the appeal is liable to be dismissed lordship. And the person is a skilled labor lordship. It has been stated lordship and
where is the evidence? Where is the evidence that he is a skilled labor? Skilled laborers also possess some kind of way and Also, that experience part, even the Ministry of Labor and Employment, why this notification, Lordship, 1352, dated 24th August 2006, it has given definition of what is unskilled work, semi-skilled work, and skilled work. While defining semi-skilled work, it says semi-skilled work means work that involves some degree of skill or competence acquired through experience on the job, which can be performed performed under the supervision or guidance of a skilled employee and includes supervisory work. Then skilled work itself is defined means work that involves skill or competence acquired through experience on the job or through training as an apprentice in a technical or vocational institute and requires initiative and judgment in performance. Lordship, I may produce the notification, but I have a summary of the notification, Lordship, if I may pass it on, Lordship. I could not download the notification itself, but I have a
No,
summary of the
that's
notification.
not, we have to go by the evidence. You tell me how you have dealt with the statement of the claimant that his monthly income is 12,000 rupees.
He used to prove it, Lordship, even if I don't challenge it. Like as I said, if a rickshaw puller and Thelawala Guwahati
No,
today puts down an income as 1 lakh per month,
No,
and
no.
I do not challenge it, will the court accept it?
No,
Lordship?
no, remaining mom in the trial court, now you people try to persuade the appellate court that his income is not so.
Lordship, the court will have to apply its mind, Lordship, even if someone doesn't challenge it. The courts are there to adjudicate, dear Lordship. No.
Court has duly applied.
I'm saying, please, let me finish. Lordship, all I'm saying is that the courts have always been seen to apply its mind, Lordship. That's why this expression
Court has
comes
applied
non-application
its
of mind.
mind because
I'm
there
saying,
is a-
Lordship, 21 is
No,
small
no,
boy.
Mr. Goswami.
Yes.
There is an affidavit of the learner of the claimant. Duly sworn affidavit is there.
Everyone does it.
Is it not affidavit? Is it not evidence?
Lordship, that I don't think will be called evidence, Lordship.
Not evidence.
Because if he sworn an affidavit, at the time of affidavit, I don't know if it always goes by.
Affidavit is not evidence.
It is evidence, Lordship. It has to be tested by cross.
Not evidence.
No, it's evidence, Lordship. I'm not saying it's evidence. But it's subject to Lordship cross-examination, Lordship. Yes, it was missing. I admit it was missing. If you say so, I haven't read it. I may read the.
And you show me how you have dealt with that issue, the income part.
Just see.
Show me the cross-examination.
It's not a fact that I did not have monthly income of about rupees 12,000.
Yes, thereby you have rebutted the evidence adduced by the claimant.
I can only say, Lords, if he has said something, I've said it's not your income. He said I have monthly income. It's not a fact. He said.
Whether-
And how
whether-
can I adduce evidence on his? Try to give a negative
Whether,
evidence here.
you have produced before the court this notification. This notification, have you shown it?
No, I don't
No.
know. I don't know. I don't know.
You do not.
It is for the Lordship, the court.
Sir, Goswami, always rely upon your argument on the basis of the evidence available in the record.
I do not know whether that was already submitted, Lordship, but I know that for a fact, because at that this also is a recent trend, Lordship, relying on medical minimum wages act. Maybe they would have shown if it was a year, but it's not a fact, it was not challenged. That was challenged, Lordship.
Counsel for
I mean, my learned friend did not represent it correctly. It was challenged that it was not
Also
12,000. He said it's 12,000.
It's not learned counsel for the rest of the argument concluded. Order reserved.
All right, Lordship.
May I please your lordship? Lordship, I'm extremely sorry, no such order is there. As today I have submitted before
Then
your
on
lordship.
what basis you have submitted?
No,
before
your
the court?
lordship. Today also I have initially submitted that perhaps this matter may not be taken up by your lordship. On that day also,
No, no,
I have not gone.
I am not interested to take up this matter.
No, your lordship, my submission was on earlier occasion. I
Hmm.
submitted before that court. I'm
No,
only sorry that.
you have submitted that there is an observation of the court. You show me the observation.
No, there is in the order, it is not reflected.
Then
But on that day, your lordship, I have
Hmm.
duly submitted.
okay.
Your lordship,
SSL is the matter before appropriate bench without me.
Lordship, 4 weeks time may be granted to me.
In
for
the
applying
meantime,
it.
you will get.
oblige your lordship.
Timing item 2.
My lord, I called for the affidavit in opposition and I advert the filing section, my lord. From yesterday, my lord, due to link fail, my lord, could not, not a single case has been registered, my lord. So maybe that's why, my lord, the affidavit not come, my lord. So I pray for, my lord, with the consent of others, that the matter taken up on 27, my lord, and Tuesday hearing day, my lord.
27.
My lord, please agree.
Okay.
Or your lordship convenient.
Mr. Talukdar, learned standing counsel for the respondent. in
Elementary
Elementary Education Department with consent from the other side, press for listing the matter on 27. As the affidavit filed by him yesterday is not placed on the record. Chair of Mr. Talukdar is accordingly allowed. This is the matter on 27. Along with the affidavit filed by Mr. Talukdar.
27 lakhs.
Timing item 9.
I beg apology, Lordship. I could not attend the court when the matter was called for due to water logging.
Right.
Lordship, in this case, the appellant as plaintiff filed a suit for seeking declaration of right title interest by a adverse position, Lordship, and as well as for permanent injunction. The defendants filed written statement and the defendant number 6 and 7, Lordship, filed counterclaim against the plaintiff. Hereafter, the plaintiff also filed written statement against the counterclaim, Lordship. After issuing evidence by both the side, Lordship, the learned trial court passed the judgment. In the judgment, Lordship, the suit of the plaintiff was dismissed and the counterclaim of the defendant number 6 and 7 was decreed, Lordship. Thereafter, title appeal was preferred before the learned district judge at Nagari, Lordship. The title appeal was dismissed again, Lordship. The judgment of the trial court is at page 34, Lordship. May I read, Lordship? This is a suit for declaration of right title and interest of the plaintiffs over the suit land for permanent injunction and for issuance of precept for the cancellation of the sale deed number 8/2011 dated 10/2011. The plaintiff's case inter alia is that the land measuring 2 kothas covered by DAG number 961 of KP Patta number 322 and land measuring 1 kotha covered by DAG number 962 of KP Patta number 305 of village Kaljar under Moja. Both the land are within the same area, Lordship, adjacent to each other, Lordship. Originally belonged to late Sharat Bhagavati, who was the father of the defendant number 1, 2, 3, 4 and husband of defendant number 5 respectively. Late Sharat Bhagavati was in possession of Schedule A land till 1994. The land measuring 2 katha and
1 katha, which are adjacent to each other, is Schedule A land lordship. During lifetime of Sarat Bhagavati, both the plaintiffs, who are the brothers, on 11/11/1994, entered into a plot of land measuring 15 lesas to occupy the position which is the western portion of the Schedule A land. These 15 lesas of land is the suit land of the instant case and specifically described in Schedule B of the plain lordship. After entering into possession of the Schedule B land, that is the suit land, the plaintiffs developed the land by earth filling and constructed one gumti over the suit land and started one shop named Baba Bhandar lordship in the gumti. The plaintiff also covered the boundary of the suit land by constructing bamboo fencing around it. Since then, the suit land has been continuously possessing by the plaintiffs till date with the knowledge of Sarat Bhagavati, who is the original owner of the suit land lordship, and his family members. The remaining portion of Schedule A land except the suit land is still under the possession of defendant number 1 to 5, being the legal heirs of Sarat Bhagavati. Since 11/11/1994, the plaintiffs continued their business in the said Gumti. Subsequently, in the year 2006, after retirement of plaintiff number 1 from service, the plaintiffs renovated their shop named Baba Bhandar into a Assam-type wooden house and started a grocery and stationery shop, keeping the name of the shop same, that is Baba Bhandar. The plaintiff number 1 was working at Defense Department, and until his retirement in the year 2006, his brother, plaintiff number 2, used to look after the business, mostly over the suit land. The plaintiff number 1 also used to look after plaintiff 1 and 2 are brothers lordship. Also used to look after the same whenever possible. The plaintiff also told Sarat Bhagavati, the real owner of the original owner of the suit land, will not be given to them anymore. Neither Sarat Bhagavati nor the defendants who used to visit the suit land raised any objection regarding the possession of the plaintiffs and construction over the suit land at any point of time. In the year 2007, the defendant number 1, with a view to start construction, raised concrete posts by the side of the suit land, which is the part of a schedule land, excluding the suit land. But the said construction could not proceed further. On 27/9/2007, Sarat Bhagavati died, leaving behind defendant number 1 to 5 as his legal heirs. All the defendants were aware about the possession of the suit land by the plaintiffs. As the house of Sarat Bhagavati stands near the suit land, on 10/2/2011, in the morning, the defendant number 1, Sri Midul Bhagavati, came to the suit land and asked the plaintiffs to vacate the suit land as he sold the entire schedule land, which includes the suit land also. The plaintiff immediately raised objection regarding the selling of the suit land and told defendant number 1 that he has no right to sell the suit land and refused to vacate the suit land. Thereafter, the plaintiff inquired about the sale deed and came to know about execution of sale deed and obtained a certified copy of the said sale deed bearing number 8/11 dated 10/2/2011, executed by the defendant number 1, Sri Midul Bhagavati, in favor of defendant number 6 and 7. Though in the sale deed it is mentioned that possession of a schedule land has been handed over to the purchaser, but in fact, defendant number 1, Sri Midul Bhagavati, still not able to hand over the possession of the land sold to defendant number 6 and 7. And therefore, defendant number 1, with a view to hand over the vacant position of a schedule land, asked the plaintiff to vacate the suit land. In spite of refusal of the plaintiffs to vacate the suit land, defendant number 1 again asked the plaintiff on 14/2/2011 to vacate the suit land immediately. But the plaintiff strongly refused to vacate the suit land. The defendant number 1 on 27/2/2011 also threatened to use force if the plaintiffs failed to vacate the suit land immediately. Again on 14/3/2011, the defendant number 1 ultimately threatened to use force if the plaintiffs failed to vacate the suit land within 10 days. The plaintiffs have stated that after the death of Sarat Bhagawati, the plaintiffs told defendant numbers 1 to 5 that the suit land will not be given to them at any cost and not to think it as their own land. The plaintiffs have been in possession of the suit land since the year 1994 and continue. The suit was filed in the year 2011, Lordship. The plaintiff have been in possession of the suit land since the year 1994 and continuing their business over there with the knowledge of Sarat Bhagawati and the present defendants. On the backside of the shop, the plaintiffs have been cultivating vegetable since the date of their possession, that is 11/11/1994. The plaintiffs have exclusive, continuous, and undisturbed possession over the suit land since 11/11/94 to the knowledge of the late Sarat Bhagawati and his legal heirs. The plaintiff's right over the suit land is adverse to the real owner of the suit land. In spite of knowing all the facts, the defendant, especially defendant number 1, sold the suit land to defendant number 6 and 7. Though the defendant number 1 executed the sale deed, but till that he could not hand over the possession of the suit land to the defendant number 6 and 7. The right of the plaintiffs over the suit land has remained into title due to efflux of time, as the plaintiffs have continuous, exclusive, and undisturbed possession over the suit land. The defendant number 6 and 7, knowing all these facts, purchased the suit land without taking delivery of possession of the suit land. The plaintiffs have been continuously possessing the suit land since 11/11/1994, and they are also members of Boroma Byabakhai Santha, and in this respect, a certificate was also issued by the Santha in the year 1995. The plaintiffs also obtained electricity connection in the name of their father in the shop situated at the suit land in the year 2006. The grocery shop of the plaintiffs is only source of earning for livelihood of the plaintiffs. The defendants remained silent since the year 1994. Suddenly, on 10 February 2011, asked the plaintiffs to vacate the suit land. The plaintiffs' possession over the suit land is hostile, as they with the knowledge of real owner entered into possession of the suit land and constructed bamboo fencing covering the suit land. The defendant number 1 illegally executed the sale deed number so-and-so in favor of defendant number 6 and 7, and therefore the said sale deed is liable to be cancelled. The defendants are no more the owner of the suit land. The plaintiffs are the real owner of the suit land by way of adverse possession, as they have been continuously possessing the suit land more than 12 years with the knowledge of the defendants. Hence, the plaintiff has filed the instant suit.
Have you enclosed the plaint in this appeal?
Lordship,
That plaint?
appeal memo has not been.
No, the plaint.
Yes, I have enclosed the plaint, Lordship.
Page number.
Lordship, at page number 6, Lordship.
6. Is there any requirement about this adverse position?
Yes, Lordship.
Paragraph number.
In various paragraphs, it has been reiterated, Lordship, especially at paragraph number 12, Lordship, at page 9. That plaint, may I read, Lordship? That the plaintiffs have been continuously possessing the suit land since the date of 11/11/1994. And they are also members of Boroma Byabakhai Santha, and in this respect, a certificate was also issued by the Santha in the year 1995. The plaintiff also obtained electricity connection in the name of their father in the shop situated at the suit land in the year 2006. The grocery shop is only source of earning for livelihood the plaintiff. The defendant, after remaining silent since the year 1994, suddenly on 10/2/2011 asked the plaintiff to vacate the Schedule B land. The plaintiff's position is hostile, as they with the knowledge of the real owner entered into possession of the suit land and constructed house thereon by developing the same and constructed bamboo fencing covering the suit land, Lordship.
No, regarding adverse position.
Yes, Lordship. It has been stated, Lordship, that in the plain, Lordship, that the plaintiff have been continuously possessing the suit land since 11/11/1994. It has been also stated in the plain that, the Lordship, that it is within the knowledge of the real owner, Lordship. It has been also specifically mentioned that their position was hostile, Lordship.
Where you have mentioned it?
In paragraph number 12, it has been stated that their position is
That your position is hostile to the real owner?
real owner, Lordship.
Where? In which paragraph?
In paragraph number 12, Lordship, at the bottom line, Lordship,
Acha. Okay. Now come to paragraph number 6 of the judgment.
yes, Lordship. Paragraph number 6, Lordship. The plaintiff have been continuously possessing the suit land since 11/11/1994. And they are also members of Boroma Gabhai Santha. And in this respect, a certificate was also issued by the Santha in the year 1995. The plaintiff also obtained electricity connection in the name of their father in the shop situated at the suit land in the year 2006. Lordship, prior to 2006, it was Gumti and no electricity connection was there, Lordship. In the 2006, Lordship, they renovated their shop to a Assam type wooden house and thereafter they took the electricity connection, Lordship. The grocery shop and as well as they also insured their shop, Lordship. The grocery shop of the plaintiff is only source of earning for the livelihood of the plaintiffs. The defendant remained silent since the year 1994. Suddenly on 10/2/2011 asked the plaintiff to vacate the suit land. The plaintiff's possession over the suit land is hostile as they with the knowledge of real owner entered into possession of the suit land and constructed bamboo fencing covering the suit land. The defendant number 1 illegally executed the sale deed number 8/2011 in favor of defendant number 6 and 7. And therefore the said sale deed is liable to be cancelled. The defendants are no more the owner of the suit land. The plaintiffs are the real owner of the suit land by way of adverse possession as they have been continuously possessing the suit land more than 12 years with the knowledge of the defendants. Hence, the plaintiff has filed the instant suit.
Okay, whether any issue was framed on this adverse position by the trial court?
Issues are at page 39, Lordship. Issues are, Lordship, number 1, whether there is any cause of action for the suit, whether the suit is made for non-joinder of parties, whether the plaintiff has been possessing the suit land for more than 12 years against the interest of the defendant.
Okay. And how this issue has been dealt with by the trial court?
Issue number
3.
Yes, Lordship. Issue number 3. issue number 3 discussion has been started from page number 41, Lordship. May I read, Lordship?
Yes.
Issue number 3, whether plaintiffs has been possessing the suit land for more than 12 years against the interest of the defendant. According to the plaintiff on 11/11/94, they entered into possession of Schedule B land, that is the suit land. And since then, they are in continuous possession of the suit land till death. The plaintiffs developed the suit land by filling earth and constructed one gumti over the suit land and started one shop named Baba Bhandar in the gumti. Later on, the plaintiffs renovated their shop into a Assam type wooden house and started grocery and stationery shop, keeping the name of the shop same, that is Baba Bhandar. The plaintiffs told Sharad Bhagavati, who is the original owner of the suit land, that the suit land will not be given to them anymore. The plaintiff have stated that neither Sharad Bhagavati nor the present defendant number 1 to 5, who are the legal heirs of late Sharad Bhagavati, who used to visit the suit land, raised any objection regarding the possession of the plaintiff and construction over the suit land at any point of time. On the other hand, the main defendants, that is defendant number 1 to 5, Lordship, denied the claim of the plaintiffs. According to the defendants, in the year 2006, the plaintiff entered into possession of the suit land with permission of late Sharad Bhagavati and shifted their shop named Baba Bhandar to the suit land and promised to vacate the land after their resettlement in the market or when Sharad Bhagavati of his legal heir asked them to vacate the land. The plaintiff, to prove their case, examined 3 witnesses and exhibited certain documents. The plaintiff have exhibited Exhibit 1, the certificate dated 2 March 1995 issued by Boromaya Bebokai Santra. Lordship, in the year 1994, the plaintiffs took the possession of the suit land, constructed a gunti, and there is a Bebokai Santra in that Boroma area, Lordship. And thereafter, after 6 months, almost 4 months, they became the member of the Boroma Bebokai Santra. And accordingly, the Boroma Bebokai Santra issued a certificate to them. The Bebokai Santra is to all the owner of the shop issued certificate, Lordship. Accordingly, a certificate was also issued to the plaintiffs. The plaintiff have also exhibited to an electricity bill dated 10/8/2006 in the name of the father of the plaintiffs. Exhibit 2 was exhibited under objection from the defendant side. Plaintiff have also exhibited insurance policy of their shop from the year 2010 to 2011, and the same is marked as Exhibit 3. In this case, the plaintiffs claim that they entered into possession of the suit land on 11/11/1994. There is no averment in the plain that on that day that took possession of the suit land in denial of the title of the plaintiff, and on that day, the plaintiff's possession over the land become adverse to the real owner. It has been specifically mentioned in the plain, Lordship. We have specifically mentioned the date that 11/11/94, we took possession of the suit land. But the learned trial court failed to consider that we have specifically mentioned the date, Lordship. The plaintiffs have
No, you have mentioned the date, but you have not mentioned that on that very day your position to the suit land was hostile to the real owners.
Yes, Lordship. But we forcefully took the possession of the land.
Forcefully.
Not forcefully, Lordship. We adversely took possession of the land, Lordship, and accordingly within the knowledge of the.
Where is that evidence that you have adversely took possession of the suit land on 11/11/1994?
All the PWs have stated, Lordship. All the PW have stated, Lordship. The supporting PW has stated the facts, Lordship, and in the evidence of PW1, it has been stated that they have taken the possession of the suit land hostile to the real owner. And impliedly, Lordship, it is if we go to the plain in toto, it is clearly.
This is the main issue. This is the main point of your argument. Adverse position.
Yes, Lordship.
So let us see the evidence of CW1. We'll resume after 5 minutes.
Yes.
Yes.
May I please, Your Lordship? Lordship, evidence on affidavit of PW1 Lordship. In various paragraph, he has reiterated the about hostile position Lordship, specifically at page 7, paragraph number 7 Lordship. It is in vernacular language Lordship.
Okay.
আমি 11/11/1994 ইংৰাজী তাৰিখৰ পৰা আজিলৈকে বিবাদী নং 1 পৰা বিবাদী নং 5লৈ জনাকৈ তেওঁলোকৰ বিৰুদ্ধাচৰণ কৰি বিবাদীয় জমি নিৰবিচ্ছিন্ন বাধাহীন আৰু শান্তিপূৰ্ণভাৱে দখল কৰি তাত দোকান দি আছো। All the requirement of the adverse possession lordship has been specifically stated by the PW1 lordship. Hostile, continuous, peaceful.
And how this piece of evidence is cross-examined?
Yes, lordship. Judgment to cross-examination, during cross-examination lordship have found it. মই পূৰ্বতে শপত পত্ৰ দাখিল কৰো।
No, no, only this piece of evidence, how it is dealt with in the cross-examination. That you were in hostile position.
Yes, lordship.
For the supplier.
Yes.
Since
11/11/1994.
11/11/1994.
আমি 11/11/1994 ইংৰাজী তাৰিখৰ পৰা from that lordship আজিলৈকে বিবাদী নং 1 পৰা বিবাদী নং 5লৈ জনাকৈ তেওঁলোকৰ বিৰুদ্ধাচৰণ কৰি বিবাদীয় জমি নিৰবিচ্ছিন্ন বাধাহীন আৰু শান্তিপূৰ্ণভাৱে দখল কৰি তাত দোকান দি আছো।
No, no, in cross-examination.
May I read the cross-examination part, lordship? The PW1 is Babul Sharma, lordship. মই পূৰ্বতে শপত পত্ৰ দাখিল কৰো। মই গোচৰত ডকুমেণ্ট দাখিল কৰিছো। এক্সিবিট 1 বৰমা ব্যৱসায় সন্থাই 2/3/95 ইংৰাজী তাৰিখে দিয়া প্ৰমাণপত্ৰ। এক্সিবিট 2 আমাৰ পিতৃ ডিজেন শৰ্মাৰ নামত থকা দোকানৰ 10/8/2006 ইংৰাজী তাৰিখৰ ইলেক্ট্ৰিচিটি বিল আণ্ডাৰ অবজেকশ্যন। এক্সিবিট 3 বাদীৰ দোকানৰ নামত থকা 2010-2011 চনৰ ইঞ্চুৰেঞ্চ পলিচি। Exhibit 4 sale deed bearing number 8/11 dated 10/2/2011. Sale deed is that lordship defendant number 1 solely sold the suit land to the defendant number 6 and 7. That sale deed has been also exhibited lordship. More thoka more dokaner pora adha bhalong durot. More thoka yate mane during lordship it has been not Xerox copy lordship written. More thoka ghor মোৰ দোকানৰ পৰা আধা ভালং দূৰত। মোৰ থকা ঘৰৰ মাটিৰ দাগ নং পাট্টা নং মোৰ মনত নাই। বিবাদীয় মাটিৰ পট্টাত 7জন পাট্টাদাৰ আছে। এই 7জন পাট্টাদাৰৰ কাৰ অংশত কিমান মাটি আছে মই নাজানো। বিবাদীয় মাটিৰ পাট্টা দুটা পাট্টাৰ দুটা দাগ আছে। এই দুয়োটা দাগ মিলি 3 কঠা মাটি আছে। পূৰ্বতে এই মাটি শৰৎচন্দ্ৰ ভাগৱতীৰ মাটি আছিল। তেওঁ ডাক্তৰ আছিল। মই শৰৎ ভাগৱতীক ছাৰ বুলি সম্বোধন কৰিছিলো। এইটো সত্য নহয় যে ডক্টৰ শৰৎচন্দ্ৰ ভাগৱতী মোৰ ডিষ্টেন্স ৰিলেটিভ আৰু তেওঁৰ সৈতে মোৰ পৰিয়ালৰ ভাল সম্বন্ধ আছিল। মই দোকান দিয়াৰ আগতে আসাম ৰাইফলছত চাকৰি কৰিছিলো। 1 এপ্ৰিল 2006ত চাকৰিৰ পৰা অৱসৰ লওঁ। চাকৰি সূত্ৰে মই অসমৰ বাহিৰত কাম কৰিছিলো। 1/4/2006 ইংৰাজী তাৰিখৰ পিছৰ পৰা মই আলাকজাৰ গাঁৱত নিগাজিকৈ বসবাস কৰিবলৈ লওঁ। 1994 চনত মোৰ দোকান বাবা ভাণ্ডাৰখন স্থাপন হৈছিল। এই দোকানখন মই ছুটীত আহি এই দোকানখন স্থাপন কৰোঁ 11/11/1994 ইংৰাজীত এই দোকানখন মই স্থাপন কৰোঁ মই দোকান স্থাপন কৰিব আহোঁতে ছুটী লোৱাৰ কোনো কাগজ পত্ৰ গোচৰত দাখিল কৰা নাই এইটো সত্য নহয় যে মই 11/11/1994 ইংৰাজী তাৰিখে দোকান স্থাপন কৰা বুলি বোকাত মিছা কথা কৈছোঁ বৰ্তমান বাবা ভাণ্ডাৰ দোকানখন 15 লেচা মাটিতে আছে এই মাটিখিনি কালজাৰ গাঁৱত পৰে এই মাটিৰ পট্টা নং 322 আৰু দাগ নং 961 আৰু 962 পিছত কয় পাট্টা নং 305 পাট্টাত মোৰ নামজাৰি নাই মই মাটিৰ খাজনা দিয়া নাই দোকানখনৰ পাট্টা নং 322 আৰু 305ৰ মাটিতে আছে নামজাৰি মৃদুল ভাগৱতীৰ নামত আছে মৃদুল ভাগৱতী মৃত ডাক্তৰ শৰৎ ভাগৱতীৰ ল'ৰা মৃদুল ভাগৱতীৰ নামজাৰি কৰ্তন কৰিবলৈ মই চাৰ্কুল অফিচাৰত কোনো আবেদন কৰা নাই দোকানৰ 15 লেচা মাটিৰ উপৰিও বিবাদীয় পাট্টাত আন মাটি আছে বিবাদীয় পাট্টাত মুঠ 3 কঠা মাটি আছে বৰমা বজাৰৰ দোকানৰ স্বত্বাধিকাৰী সমীন বৰ্মন আৰু গণেশ বৰ্মনক মই চিনি পাওঁ these are different number 6 and 7 lordship সমীন বৰ্মনক 6 নং বিবাদী আৰু গণেশ বৰ্মনক 7 নং বিবাদী হিচাপে এই গোচৰত দিয়া হৈছে মোৰ দখলত 15 লেচা মাটি 6 নং আৰু 7 নং বিবাদীয়ে কিনিছে আৰু সেইবাবে মই তেওঁলোকক বিবাদী কৰিছো এক্সিবিট 4 মতে সমীন বৰ্মন আৰু গণেশ বৰ্মনে 3 লাখ টকাত তফসিল বৰ্ণিত মাটিত কিনা দেখা যায় এইটো সত্য নহয় যে এক্সিবিট 4ত মোৰ দোকান থকা মাটিৰ দলিল নহয় here in this play they put a suggestion lordship that the schedule of the sale deed is not similar to the land possessed by us এইটো সত্য নহয় যে exhibit 4 that means exhibit 4 is the sale deed by which the defendant number 1 sold the suit land to the defendant number 6 and 7 মোৰ দোকান ঘৰৰ মাটিৰ দলিল নহয় 1994 চনত মই দোকান স্থাপন কৰি বৰমা ব্যৱসায় সন্থা মোৰ নাম অন্তৰ্ভুক্ত কৰোঁ বৰমা ব্যৱসায় সন্থাৰ খ শ্ৰেণীৰ দোকান মোৰ ডাঙৰ হোলচেলৰ দোকান বৰমা ব্যৱসায় সন্থাৰ ক শ্ৰেণীৰ দোকানবোৰ ডাঙৰ হোলচেলৰ দোকান খ শ্ৰেণীটো তাতকৈ অলপ সৰু অৰ্থাৎ এইটো ৰিটেইল সেলৰ দোকান গ শ্ৰেণীৰ দোকানবোৰ সৰু দোকান এক্সিবিট 1 মৰ্মে বাবা ভাণ্ডাৰ দোকানখন কোনখিনি মাটিত অৱস্থিত সেই সম্পৰ্কে কোনো উল্লেখ নাই বৰমা ব্যৱসায় সন্থা 1986 চনত আৰম্ভ হৈছে এই সন্থাৰ প্ৰতিষ্ঠিত সভাপতি আৰু সম্পাদক কোন মই নাজানো 1994-95 এই সন্থাৰ সভাপতি সম্পাদক কোন আছিল মই নাজানো actually if your lordship kindly goes to the LCR in my certified copy it has been stated as Najanu but in the LCR the original copy that is Janu if your lordship kindly goes to the LCR 1994-95 এই সন্থাৰ সভাপতি সম্পাদক কোন আছিল মই জানো
Original evidence, original cross-examination is before this court. Here also it is stated that Pun Moy Nazano.
It has been stated Nazanu.
Yeah.
In certified copy, it has been stated Nazanu, but the engaged counsel in the trial court informed me like this, lordship. That's why.
You see the original record.
Okay. সেই সময়ত সভাপতি বিপুল শৰ্মা আছিল আৰু সম্পাদক বিশ্বেশ্বৰ বৰ্মন আছিল That's why I am really confused whether he specifically stated the name of the president and secretary, but in the recording of cross-examination, it has been stated as Nazanu. সেই সময়ত সভাপতি বিপুল শৰ্মা আছিল আৰু সম্পাদক বিশ্বেশ্বৰ বৰ্মন আছিল The Bipul Sharma is the PW2 lordship who was at that time of issuing the exhibit 1 lordship. He was the president of the Boroma Bebahai Honta and he adduced his evidence in the court. তেওঁলোক দুজনক মোৰ গোচৰত সাক্ষী দিছো both the secretary and president adduced their evidence and PW2 and 3 lordship সুটলেণ্ডৰ ওচৰৰ আন দোকানী বা স্থায়ী বাসিন্দাক মোৰ গোচৰত সাক্ষী মান্য কৰা নাই মোৰ দোকানৰ দক্ষিণ কাষত মৃত উত্তম বৰ্মনৰ ঘৰ আৰু ব্যৱসায় থলী উত্তম বৰ্মনৰ মৃত্যু হৈছে বৰ্তমান উত্তম বৰ্মনৰ ঘৰত তেওঁৰ ল'ৰা মনুধৰ বৰ্মন থাকে মোৰ দোকানৰ লগালগি কৈ পশ্চিমে নাৰায়ণ বৰ্মনৰ চাহৰ দোকান পূবে তৰুণ বৰ্মনৰ চাহৰ দোকান। উক্ত চাহৰ দোকান দুখনত বহুত মানুহ আহি থাকে। নাৰায়ণ বৰ্মন আৰু তৰুণ বৰ্মনৰ সৈতে মোৰ সম্পৰ্ক ভাল। তেওঁলোকক মই সাক্ষী দিয়া নাই। সাক্ষী বিপুল শৰ্মাৰ ঘৰ, the PW to the then president of the বৰমা ব্যৱসায়ী সঞ্চালকশ্বিপ। সাক্ষী বিপুল শৰ্মাৰ ঘৰ মোৰ দোকানৰ পৰা 3 কিলোমিটাৰ দূৰত। তেওঁৰ বৰমাত হোলচেলৰ দোকান আছে। তেওঁৰ দোকান মোৰ দোকানৰ পৰা প্ৰায় 300 মিটাৰ দূৰত। বিপুল শৰ্মাৰ দোকানখন মোৰ দোকানৰ একে লাইনত নহয়। মই তেওঁৰ পৰা বস্তু নিকিনো। The learned counsel for the defendant tried to establish just he is a interested witness, Lordship. But the PW has specifically stated মই তেওঁৰ দোকানৰ পৰা বস্তু নিকিনো। এইটো সত্য নহয় যে মই তেওঁৰ দোকানৰ পৰা ষ্টেচনাৰী মাল কিনো বাবে তেওঁ মোৰ হৈ সাক্ষী দিব আহিছে। বৰ্তমান বৰমা ব্যৱসায় সন্থাৰ সভাপতি সম্পাদকৰ নাম মোৰ মনত নাই। এইটো সত্য নহয় যে 1994 চনত বিপুল শৰ্মা আৰু বিশেশ্বৰ বৰ্মনৰ ক্ৰমে সভাপতি সম্পাদক নাছিল আৰু কুমুদ দত্ত আৰু ধৰণী কলিতা ক্ৰমে সভাপতি আৰু সম্পাদক আছিল। 2007 চনত মোৰ দেউতা দ্বিজেন শৰ্মা ঢুকাল। বৰ্তমানো আমাৰ দোকানৰ ইলেক্ট্ৰিচিটি লাইন দেউতাৰ নামত চলি আছে। মোৰ দেউতা দ্বিজেন শৰ্মা মোৰ দোকানৰ বাবা ভাণ্ডাৰৰ স্বত্বাধিকাৰী নাছিল। এক্সিবিট 2ত বাবা ভাণ্ডাৰৰ নাম উল্লেখ নাই। এক্সিবিট 2 কমাৰ্চিয়েল শব্দটো নাই। এক্সিবিট 2 is the electricity bill, Lordship. এইটো সত্য নহয় যে এক্সিবিট 2খন মোৰ ঘৰৰহে ইলেক্ট্ৰিচিটি লাইনৰ বিল, দোকানৰ নহয়। এক্সিবিট 3 ইনচুৰেঞ্চ পলিচি চনৰ পিৰিয়ড 21/7/2010 to 20/7/2011 মই দোকানৰ ইনচুৰেঞ্চ পলিচি 2000 চনৰ পৰা কৰিছো। 1994 ইনচুৰেঞ্চ পলিচি কৰা নাই। এইটো সত্য নহয় যে 1994 চনত বাবা ভাণ্ডাৰ নামৰ কোনো দোকান বিবাদীয় মাটিত নাছিল। সুটলেণ্ডৰ 15 ডেচা মাটিৰ ভিতৰত বাবা ভাণ্ডাৰ দোকানৰ পিছফালৰ মাটিখিনি মই বস্তি মাটিলৈ ৰূপান্তৰিত কৰিছো। কেছ কৰাৰ আগত ৰূপান্তৰিত কৰিছো। এইটো সত্য নহয় যে কেছ লগাৰ পাছত এই মাটি বস্তি মাটিলৈ ৰূপান্তৰিত কৰিছো। 6 নং আৰু 7 নং বিবাদীক মোৰ বিৰুদ্ধে কৰা ইনজাংচন কেছৰ নটিচ মই পাইছো। এই গোচৰত আদালতে ষ্টেটাছ কো মেইনটেইন কৰিবলৈ হুকুম দিছে। সেইমতে মই আদালতৰ হুকুম মানিছো। এইটো সত্য নহয় যে পূৰ্বতে বাবা ভাণ্ডাৰখন ভাটনা ৰাভাৰ ঘৰত আছিল। এইটো সত্য নহয় যে মই চাকৰিৰ পৰা অৱসৰ লোৱাৰ পিছত 2006 চনত শৰৎ ভাগৱতীৰ অনুমতি ক্ৰমে তেওঁৰ মাটিত বাবা ভাণ্ডাৰ দোকান স্থাপন কৰো। শৰৎ ভাগৱতীৰ 2জন ল'ৰা চাকৰি সূত্ৰে বাহিৰত থাকে। শৰৎ ভাগৱতীৰ 29/9/2007 ইংৰাজী তাৰিখে মৃত্যু হয়। মৰাৰ 2 বছৰমান আগৰ পৰা তেওঁ বিচনাত পৰি থকা বুলি শুনিছো। এইটো সত্য নহয় যে শৰৎ ভাগৱতীয়ে তেওঁৰ প্ৰয়োজনত মাটি ঘূৰাই দিব লাগিব বুলি মোক কৈছিল আৰু সেইমতে মাটিত মোক দোকান কৰিব অনুমতি দিছিল আৰু মই মাটি ঘূৰাই দিম বুলি অংগীকাৰ কৰিছিলো। By putting such suggestion, they have already admitted that we are in possession of the suitland. মই স্থাপন কৰা সময়ত মোৰ দোকানখন গুমটি আছিল আৰু বৰ্তমান এইখন গুমটি নহয়। 1994 চনত মই ইম্ফলত চাকৰি কৰি আছিলো। আমি এবছৰত 2 মাহ ছুটি পাওঁ। এইটো সত্য নহয় আমি 2 মাহ ছুটি নাপাওঁ। এইটো সত্য নহয় যে বিবাদীয় মাটিত মোৰ এডভাৰ্স পজিশন নাই। এইটো সত্য নহয় যে মিছা কথা ক'ব লাগিব বুলি মোৰ দোকানৰ ওচৰত মানুহে সাক্ষী দিব অহা নাই। The only during cross-examination, Lordship, the counsel for the defendant regarding adverse position only put this suggestion.
But
Otherwise,
it appears that you were in service till 2006.
Yes, Lordship.
And you have insured your shop in the year 2007.
Yes, Lordship.
Okay.
Lordship, what happened? Here are 2 plaintiffs, Lordship. Babul Sharma, the PW1 is the elder brother, and Obi Sharma is the younger brother. Since 1994, Lordship, the younger brother took care of the Gumti Lordship. And in the 2006, when the PW1, the plaintiff number 1, got retirement, both of them jointly renovated their shop from a Gumti to a stationary Dukan Lordship in a Assam type house, wooden house. And accordingly, prior to the Assam Type House, as they were running the small Gumti lordship, no electricity connection was there. No insurance policy was required for the small Gumti lordship. And when they invested a lots of money in the shop in the year 2006, they took electricity connection lordship, insured their shop lordship. Only this paragraph has been put to the with PW1 regarding adverse position of the, otherwise they could not rebutted the evidence of the PW1 lordship.
Okay, then how the trial court has dealt with the issue?
Lordship, issue number 3, lordship.
Issue number 3.
Issue number 3, lordship. Whether plaintiff has been possessing the suit land for more than 12 years against the interest of the defendant. According to the plaintiff on 11/11/1994, they entered into possession of
You have already read some of the paragraphs of that issue. Issue number 3.
Issue number 3 at page number 41, lordship. And I
You
have read
already
the
some of the portion.
I have read the paragraph number 16, lordship. Partly paragraph number 16, lordship.
Okay.
For line number 5, lordship, of paragraph 16, lordship.
No. You have read some of the portion of paragraph number 19 also. From start from paragraph number 19,
19, lordship.
page number 44.
Yes, lordship. In this case, the plaintiffs claim that they entered into possession of the suit land on 11/11/94. There is no averment in the plain that on that day they took possession of the suit land in denial of the title of the plaintiffs, and on that day the plaintiff's position over the suit land becomes adverse to the real owner. In the evidence of affidavit, we have specifically stated, lordship, and no question was put regarding that, lordship. And as well as we have also stated in our plaint, lordship, that from the date of 11/11/94,
Yes.
the plaintiffs have stated that they told Sharat Bhagavati, who is the original owner of the suit land, that the suit land will not be given to them anymore. But there is no specific averment in the plain as to the date when they informed the original owner that the suit land would not be given back to him, lordship. We took position on 11/11/94. It is not logical that on same day we will go to the residence of the late Sharat Bhagavati and tell him that we have taken possession of your land. Sharat Chandra Bhagavati resides near the suit land, and it is also admitted by the defendants. His legal heirs in the in front of them, we have taken position of the suit land lordship. It is my humble submission that that person who takes possession of a suit land, hostile position lordship, why he will go to the resident of him and will tell that I have taken your land, I have taken possession of your land hostilely, lordship. So mention of the death when explanation regarding this sentence, lordship, the requirement of the death when I told Thorat Bhagavati that we have taken possession of your land is not required, lordship. But there is no specific amendment in the plain as to the death when they inform the original owner of the owner that the suit land would not be given back to him. Therefore, there is no pleading from the side of the plaintiff as to the death from when the starting point of adverse position would be commenced. My humble submission from the 11-11-94 itself, the starting point of adverse position would be commenced, Your Honor.
Yes.
The plaintiffs have also stated that neither Horat Bhagavati nor the present defendant number 1 to 5, who are the legal heirs of late Horat Bhagavati, who used to visit the suit land, raised any objection regarding the possession of the plaintiff and construction over the suit land at any point of time. This statement of the plaintiff clearly indicates that the plaintiff position over the suit land was not objected by the real owner, and they impliedly permitted the plaintiff to possess the suit land. This is also learned trial court failed to consider, wrongly took the opinion that as they did not raise objection, that means impliedly it is permissive occupier. We are permissive occupier. The principle of law firmly established that a person who bases his title on adverse position must show by clear and unequivocal evidence that his position was hostile to the real owner and amount to denial of his title to the property claim. This, though the learned trial court failed to consider this aspect, lordship, but we have specifically in our evidence on affidavit in the plain specifically stated, lordship, to show that we have established our title on adverse position, Your Honor. Paragraph number 20, Your Honor. The plaintiff has examined 3 witnesses in the suit, including plaintiff number 1 as PW1, PW2, Bipul Sharma has deposed that in the year 1994-95, he was the president of Boroma Bevahai Santa. In the year 1994, the plaintiffs became member of Boroma Bevahai Santa in the name of heirs of Baba Bhandar. On the basis of annual inspection, Exhibit 1, the certificate was issued to the plaintiff as sought by them. During inspection, PW2, the president of the Bevahai Santa Lordship, found the shop of the plaintiff over the same land where it is now situated. The stand of the defendant is that till 2006, where our shop was at another place, and after 2006, we have changed the place of the shop, lordship. But the president himself stated that he himself inspected, lordship, and specifically mentioned that during inspection, PW found the shop of the plaintiffs over the same land where it is now situated. In the year 2006, the plaintiff constructed the Assam type house for the shop by removing the gumti. Both PW2 and 3 have deposed that since the year 1994, the plaintiffs are in possession of the suit land continuously and peacefully. But none of PW2 and 3 has deposed that the plaintiff position over the suit land is in denial of the title of the real owner. Lordship, they are independent witness. They cannot explain what is going on in between the real owner and the possessor, lordship. They have also stated the facts. Their facts is that they are doing business over the suit land by constructing the gumti since 1994 till then, lordship. It is to be noted that possession, however long, does not confer any title over the land unless it is shown that possession is adverse against the interest of the real owner. Animus possidendi is one of the ingredients of adverse possession. Unless the person possessing the land has a requisite animus, the period for prescription does not commence. Paragraph number 21, Lordship. In the case of Karnataka Board of Waqf versus Government of India 2004, 10 SCC 779, the Honorable Apex Court held as follows. In the eye of law, an owner would be deemed to be in possession of a property so long as there is no intrusion. Non-use of property by the owner, even for a long time, won't affect his title, but the position will be altered when another person takes possession of the property and asserts a right over it. But it has been done by the plaintiff's lordship. Adverse possession is a hostile position by the clearly asserting hostile title, asserting hostile title in denial of the title of the true owner. It is a well-settled principle that a party claiming adverse possession must prove that his possession ni claim ni precario. That is peaceful, open, and continuous. It is already in the plain, and by filing adducing evidence, it has been established by the plaintiffs that, lordship, the possession of the plaintiff is peaceful, open, and continuous. The possession must be adequate in continuity, in publicity, and in extent to show that their possession is adverse to the real or true owner. It must start with a wrongful disposition of the rightful owner and be actual, feasible, exclusive, hostile, and continued over the statutory period. Physical fact of exclusive possession and the animus possidendi to hold as owner in exclusion to the actual owner are the most important factors that are to be accounted in case of this nature. Plea of adverse possession is not a pure question of law, but a blended one of fact and law. Therefore, a person who claims adverse possession should show on what date he comes into possession. On 11/11/94, lordship, we came into possession. What is the nature of his position? Our position was hostile, lordship. Continuous position, peaceful position. We have specifically mentioned in plain and the evidence on affidavit, lordship. Whether the factum of possession was known to the other party, it has also been stated stated in the plain and evidence, and the defendant has not denied that they do not know that the plaintiffs are in possession of the suit property, suit land, lordship. How long his position has continued? It is more than 12 years, lordship. His position was open and undisturbed. It has also been stated, lordship. Position was open. The defendant, their deceased father, public, nearby public, everyone knows that the plaintiffs are possessing the suit land, lordship. And no disturbance took place in prior to filing of this case, lordship. Prior to filing, just few days prior to filing of this suit, we only got disturbed. Till then, since 1994, our position was undisturbed, lordship. A person pleading adverse possession has no equity in his favor. Since he is trying to defeat the right of the true owner, it is for him to clearly plead and establish all facts necessary to establish in his adverse position. Then paragraph number 22, lordship. In this case, there is no averment in the plain debt on the debt when the plaintiff entered into possession of the suit land. Their position was adverse to the real owner. Only the point is taken by the, considered by the trial court is that on the, it has been admitted by the defendant and also understood by the trial court that we are in possession since 11/11/1994. But the learned trial court's opinion is that on that day our position was not hostile. Only on that.
No, that's all right. But is there any material to show that from 11/11/1994, even if it is accepted that you were in possession of the suit land, your position was hostile to the real owner?
Lordship, to show on 11/11/94, lordship, we openly took the position of the suit land. the residence of the defendants is nearby the Suitland Lordship. They are very aware of that. On that day we have, they may not remember the date, but they know that we took position on the same date. They took come to know that we have taken the position of the Suitland Lordship. But even though they did not raise objection, and why we should go to him and tell that we have taken your land in position of us and will not give it to you. Whether it is required, Lordship, this is not required. This impliedly,
Is it?
it is, Lordship, it is impliedly,
No, what is the requirement of the law?
as per my little knowledge, Lordship, if in case of adverse position, the position should be hostile, continuous, peaceful, in the knowledge of the real owner, and open, Lordship.
No, the question is whether it was hostile from that day, 11/11/1994.
My, if it is not hostile, Lordship, I want to submit that, I beg to submit that. Is there, there is no way for the plaintiff to, on the date of position, to establish before the learned court, to establish that on the same date, they have to show any facts which shows that it became hostile, Lordship. As because it is within the knowledge of the, we have not done it that the real owner is far away from the Suitland. They are not aware of that. Even though they knowing the fact, Lordship, they did not raise objection. It does not mean that they have impliedly permitted. And as they have not permitted us, then it is automatically it is hostile, Lordship. My humble submission, Lordship.
No, that has to be examined in the light of the stand taken by the defendant in their written statement.
Lordship, in the evidence on affidavit, we have specifically stated in the vernacular language, Lordship, that from the date of, from 11/11/94, our position is hostile. We have.
No, that's all right. You have taken the plea in your pleading and also in your affidavit. But what are the materials to show that your position from 11/11/1994 is hostile? Whether your averment or your statement in your affidavit is sufficient?
Lordship, the defendant have also did not rebutted the statement of the witnesses, Lordship. During cross-examination, they did not put any suggestion regarding this, that on the.
No, they have put their suggestion. One suggestion is there in the cross-examination of the plaintiff.
Their suggestion is, Lordship, we are in position of since 2006. They are not telling that though you are in position of the Suitland from 11/11/94, but your position was not hostile. Their stand is.
Okay. Let us see how the trial court has concluded on this point.
Issue number 3, Lordship.
No, yes. Paragraph number, you were reading paragraph number 22.
22, Lordship.
Yes.
In this case, there is no averment in the plain death on the date of death. When the plaintiff entered into possession of the Suitland, their position was adverse to the real owner. That apart, the evidence adduced by the plaintiff are not sufficient enough to hold that the plaintiffs are in possession of the Suitland since 11/11/1994. Learned counsel for the plaintiff has submitted that since 1994, the plaintiffs are in possession of the Suitland. Plaintiffs have exhibited Exhibit 1, the certificate issued by Boroma Bebokai Santa, to prove their position. In the year 2006, the plaintiff's right over the suit land remain into title by virtue of adverse position. Learned counsel for the plaintiff has argued that DW1 is the defendant number 1, Lordship, stated that where the Baba Bhandar is situated, the date on which his father permitted the plaintiff to construct the shop is not mentioned in his evidence. The defendant case is that, Lordship, their father permitted us to run the shop, Lordship. As the plaintiff has not stated in evidence or claim that from 11/11/94 that is hostile. Accordingly, they could not state that from on which date they permitted us to run the shop, Lordship. The date on which his father permitted the plaintiff to construct the shop is not mentioned in his evidence. According to the learned advocate for the plaintiff, the defendants miserably failed to prove the plea of permissive possession. Paragraph number 23, Lordship. On the other hand, learned counsel for the defendant has submitted that the plaintiffs, to prove their case, mainly raised on only one document, that is Exhibit 1. In Exhibit 1, nowhere it is stated as to where Baba Bhandar is situated. PW1 revealed that it is not mentioned in Exhibit 1 over which plot of land Baba Bhandar is situated. It is very normal, Lordship, in a Bevakhay Santa when issue certificate, they mentions the classification of the shop, owner of the shop, date of membership, on which tag number, on which pattern number the land is situated is normally does not mention, Lordship, in a certificate issued by the any Bevakhay Santa, Lordship. Other plaintiffs witnessed have also not deposed that Baba Bhandar was over the suit land since 1994. Actually, this learned trial court miserably failed to consider that the PW2, PW3 also stated that Baba Bhandar was over situated the suit land since 1994. If your Lordship kindly goes to the evidence on affidavit of PW2 and 3, they have specifically stated, and their evidence could not be rebutted by the defendant side. Exhibit 1 was issued in the year 1995. But in the part of Exhibit 1, name of both the district Baksar and Nalbari were mentioned, whereas in the 1995, the district Baksar was not in existence. Lordship, what happened? Boroma belongs to a Bodoland area. And during that time, Lordship, the Bodoland Liberation Tigers and National Democratic Front of Bodoland were very violent at that time. And the local people of the Boroma and Bodoland area was tortured, and they forced to write in the signboard as Bodoland, Udayasol, such name, Lordship. And the Boroma Bevakhay Santa was also forced to use one district of Assam and another district of Bodoland, Lordship. That's why in the certificate, both the name of the district is mentioned, Lordship. In this regard, learned counsel for the plaintiff has submitted that it is not possible to give description of land in Exhibit 1. The plaintiffs filed Exhibit 1 along with the plain, but the defendant have not disputed the document in their written statement. They have not stated anything in their written statement whether we have filed the documents along with our plain, Lordship. The Bhatnarabha was not examined to prove that the plaintiff's gumti was over his hand. Their allegation is till 2006, our shop was situated over a land, namely Bhatnarabha, but they did not give evidence of Bhatnarabha to establish in the court that our suit land was not in the place where now it is situated, Lordship. It appears that Exhibit 1 cannot be a proof of possession of the suit land by the plaintiffs. Thus, this certificate was issued to the plaintiffs for their membership in Boroma Bevakhay Santa, for their grocery shop named Baba Bhandar. But the president of the Bevakhay Santa, who is PW2, Lordship, he specifically stated that he visited the shop, Lordship, and after visiting the shop, he issued certificate, Lordship, and also stated that at that time where the shop was there, now at present it is situated at the same place, Lordship. There is no mention in the said certificate that the plaintiff shop is situated over the suit land. Hence, this document cannot be regarded as proof of possession over the suit land. There is no other document produced by the plaintiff as proof of their possession over the suit land since 1994. Exhibit 2, the electricity bill, is also not in the name of the plaintiffs. The bill is in the name of father of the plaintiffs, and as such, bill also not proof of plaintiff's possession over the suit land. Lordship, what document may have a Gumti, Lordship? Lordship, the PW1, PW2, PW3, everyone has specifically stated. mentioned.
Okay, you come to the next paragraph.
Yes, Lordship. In this case, the burden of proof is upon the plaintiff to prove that they are in possession of the suit land more than 12 years against the interest of the defendant. If the plaintiffs able to create a high degree of probability of their title to ownership instead of proving his title beyond all reasonable doubt, it would be enough to shift the honors to the defendant. But in this case, the plaintiffs miserably fail to create a high degree of probability that they are in possession of the suit land adversely against the interest of the defendant for more than 12 years. Thus, the plaintiffs have failed to shift back the onus of proof to the defendants. Hence, failure of the defendant to examine the person upon whose land the Gumti of the plaintiff was previously situated does not establish the plea of plaintiffs. Moreover, it is pertinent to mention herein that PW3, Sri Visheshwar Burman, who reveals in cross-examination that there is a Gumti of the plaintiffs over the land of Khatnarapa. The plaintiffs have also claimed that in the year 2006, they renovated their shop Baba Bhandar to an Assam-type wooden house and started a grocery and stationery shop, keeping the name of the shop same, that is Baba Bhandar. And in the same year, the installed electricity connection in their shop in the name of their father. As per the pleadings of plaintiffs, prior to renovation, the shop Baba Bhandar was running in a Gumti, and it is the plaintiff witness PW2 who revealed that there was a Gumti of the plaintiff over the land of Khatnarapa. PW2 have never stated that Khatnarapa, there is a Gumti at the land of Khatnarapa.
Let us see the evidence of PW2.
Yes, Lord. PW2 is Your Honor Sri Bipul Kumar Sharma. মই বিপুল শৰ্মা, পিতা স্বৰ্গীয় কনক চন্দ্ৰ শৰ্মা, বয়স 48 বছৰ, পেছা ব্যৱসায়, ঠিকনা গাঁও দহগাঁৱনীয়া, ডাক বৰমা, থানা বৰমা, জিলা নলবাৰী, অসম। ধৰ্মৰ নামত শপত খাই কওঁ যে মই এই গোচৰৰ বাদীগণ আৰু বিবাদীগণক ভালদৰে চিনি পাওঁ। যিহেতু বিগত 20 বছৰতকৈ অধিক কাল মই বৰমা অঞ্চলতে ব্যৱসায় কৰি আহিছো, সেয়েহে এই গোচৰৰ বিবাদ সম্পৰ্কে মোৰ যথেষ্ট ব্যক্তিগত জ্ঞান আছে। 1986 চনত বৰমা অঞ্চলৰ ব্যৱসায়ীসকলে একগোট হৈ ব্যৱসায়ীসকলৰ উন্নতিৰ হকে এটা সন্থা গঠন কৰে। এই সন্থাটোৰ নাম সৰ্বসন্মতিক্ৰমে বৰমা ব্যৱসায় সন্থা ৰখা হয়। 1994 চনত বাদীগণে তেওঁলোকৰ দোকান বাবা ভাণ্ডাৰৰ নামত বৰমা ব্যৱসায় সন্থাৰ সদস্য ভৰ্তি হয়। তেতিয়াৰ পৰাই তেওঁলোক বৰমা ব্যৱসায় সন্থাৰ আজিলৈকে নিয়মীয়া সদস্য হৈ আহিছে। 1994-95 চনত মই ব্যৱসায় সন্থাৰ সভাপতি আছিলো। অইন বছৰৰ দৰে সেই বছৰো আমি বৰমা ব্যৱসায় সন্থাৰ বিষয়ববীয়াসকলে আমাৰ সন্থাৰ অন্তৰ্গত দোকানসমূহৰ বছৰেকীয়া পৰ্যবেক্ষণ চলাইছিলো। তদুপৰি বাদীগণে বিচৰা কাৰণে সেই পৰ্যবেক্ষণৰ ওপৰত ভিত্তি কৰি বাদীগণৰ দোকান বাবা ভাণ্ডাৰৰ নামত এখন প্ৰমাণ পত্ৰ প্ৰদৰ্শক এপ দিছিলো। 1995 চনত আমি পৰ্যবেক্ষণ কৰাৰ সময়ত বাদীগণৰ দোকান বাবা ভাণ্ডাৰ দোকানখন যি স্থানত অৱস্থিত আছিল, আজিও দোকানখন সেই একে স্থানতে অৱস্থিত হৈ আছে। মাত্ৰ 2000 চনত বাদীগণে বিবাদীয় জমিৰ পৰা গুমটি ঘৰটো আঁতৰাই তাৰ স্থানত এটা আছাম টাইপৰ ঘৰ বান্ধি ব্যৱসায় বৃদ্ধি ঘটায়। পদক্ষৰ 1 বৰমা ব্যৱসায় সন্থা 2-3-1995 ইংৰাজী তাৰিখে বাদীগণক দিয়া প্ৰমাণ পত্ৰ। পদক্ষৰ 1 ক বৰমা ব্যৱসায় সন্থাৰ তদানীন্তন সভাপতি হিচাপে বাদীগণক দিয়া প্ৰমাণ পত্ৰত মোৰ স্বাক্ষৰ। মই দেখিবলৈ পাইছো যে বাবুল শৰ্মা আৰু কবি শৰ্মা, that is the plaintiff lordship, শৰ্মাৰ দখলত থকা মাটিৰ পৰিমাণ প্ৰায় 15 লেচা আৰু এই মাটিখিনি প্ৰকৃততে শৰৎচন্দ্ৰ ভাগৱতীৰহে আছিল। মই বাবা হানুৰা দোকানখনৰ দোকানী শ্ৰী বাবুল শৰ্মা আৰু কবি শৰ্মাক 1994 চনত দোকান স্থাপন কৰাৰ দিন ধৰি আজিলৈকে একেৰাহে শান্তিপূৰ্ণভাৱে গোচৰ লগা মাটিত দোকান চলাই অহা দেখিছো। এইখিনিয়ে মোৰ সাক্ষ্যত ক'বলগীয়া। During the cross-examination, lordship, also he has not stated like that the land of Suitland is situated at Patnarabha, lordship. May I go through may I read the cross-examination part, lordship?
But this witness has not disclosed about that your position is hostile to the owner. He simply stated about the position.
Yes, lordship. It's because, lordship, he does not know what is going on in between the plaintiff and the defendants. He has stated only the facts, which is within his knowledge, lordship. He knows that the shop was established, Gumti was established in the year 1994. Thereafter, they took certificate from there, and since then they are running their business at the same place. Only they in the year 2006 they have renovated their shop. The evidence was deposed by the person who himself issued the certificate, lordship, as because he has proper knowledge regarding the position of the plaintiff over the Suitland, lordship. And yes, he has not stated regarding whether the position is hostile. He only stated that their position is continuous.
So in cross-examination also, this witness has not stated that it was in the land of Bhatnarabha.
Yes, lordship.
So yes, Mr. Dekka, whether this witness has stated.
No, this is a typographical mistake, my lord. Usually, the PW 3, my lord. She has stated.
He has stated.
Yes, prior to that, my lord, this clearly stated in the earlier portion, PW 3.
Cross-examination.
Yes, my lord. PW 3, my lord.
Which part?
My lord, in judgment also and the evidence also, my lord. 3 number, no?
Yes. Bhatnarabhar matit badir gumti eta asil. Ketiar pa asil moi najan.
Yes, that is
Yes, it is correct, lordship.
Our
Prior to 1994, we had a
pleading also here, my lord. Earlier, the Gumti was in Bhatnarabhar's residence. In 2006, on the permission of the plaintiff's father, defendant's father, my lord. He as a permissive occupier, my lord. Permissive occupier, nothing.
Since 2006.
Yes, my lord. It is not 12 years in 2011. Suit is filed in 2011, my lord. Since 2006, he is permissive occupier, my lord. And the document he has submitted, electricity bill, everything, although it is not related to the land, that is also 2006, my lord. And he retired in 2006, my lord.
Insurance in 2007.
Yes, my lord. So the electricity insurance is 2011, my lord. He retired from the army, my lord, in 2006, my lord. So, my lord, there is no any position in 2011, my lord. In 2006, my lord. It's a permissive occupier.
So, Mr. Soma, this is your cross-examination, wherein this witness admitted that Bhatnarabhar matit badir gumti eta asil.
Yes.
Yes, lordship. We have never denied it. Prior to 1994, there is a Gumti at the land of Bhatnarabha, lordship. In 1994, we came to that place, Lordship. It has not been stated that.
Not stated, my lord. Nowhere stated that earlier there was a.
Yes.
Prior to 1994, my lord, there was a Gumti in the Bhatnas Rivers place, my lord. They come, no, my lord. It is beyond evidence, my lord. No evidence is there, my lord.
We
And
have.
he is running a Gumti prior 1984 in the Bhatnas River land, my lord. It is nowhere he has stated, my lord.
It is their question. After questioning by the defendant, we have to
Definitely.
state it. But
Definitely, this is
as
the-
per the,
No, this is cross-examination.
yes, Lordship.
You have cross-examined the witness.
No, no, Lordship. My
Oh,
witness has
yes,
been,
okay.
my witness has been cross-examined.
Okay.
Yes, it is correct that prior to 1994, the plaintiff number 2, he tried to
No,
run a.
but this fact is not in your pleading.
Yes, Lordship. That's because we
And
have,
in your evidence also.
we have stated the,
Prior to 1994, you had one.
this was
fee
the, prior to
over the
1990,
land of Bhatnarava.
prior to 1994, the shop did not belong to the plaintiff number 1, Lordship. Both the did not belong to plaintiff, both the plaintiffs, Lordship. And they just tried to run the business. And as we have claimed for adverse person since the year 1994, that's why we have stated all the facts since the 11/11/1994, Lordship. As because prior to running the business at the land of Bhatnarava, the plaintiff number used to work as a helper in another grocery dogan. That is also not mentioned, Lordship. As because, as this is a case of adverse possession, Lordship, and since when the adverse, we have claimed adverse possession over this suit land, Lordship. And that's why we have stated all the facts after 11.
So, except this adverse position, do you have any other point? What is the substantial question of law here?
Yes, Lordship. Two substantial question of law were formulated, Lordship. Whether the learned court below committed error in declaring the title of the defendant number 6 and 7 over the full plot of land. And whether in absence of any issue regard to recovery of possession, the learned court below committed error in decreeing the counterclaim of or eviction of the plaintiff over the suit land. Lordship, in the counterclaim, there is no prayer for declaration of right title interest, Lordship. But
in contract claim?
Yes, Lordship. But learned trial court declared right title interest of the defendant number 6 and 7 over the suit land, Lordship. And the learned trial court also confirmed it. Whereas, Lordship, if your kindly Lordship goes to the issue.
Okay, Mr. Soma.
Yes, Lordship.
We'll resume at 2 o'clock.
Yes, Lordship. Highly obliged.
Item number 9 to continue.
Lordship, the substantial question of law, two substantial question of law formulated by the court, Lordship. Whether the learned court below committed error in declaring title of the defendant number 6 and 7, that are counterclaimant, Lordship, over the full plot of land. The defendant number 6 and 7 in their counterclaim never prayed for declaration of right title interest, Lordship. But that issue was framed and decided.
Let us see the counterclaim.
Counterclaim it is at page 20, Lordship.
Page
20, Lordship.
20?
Yes, Lordship. And the prayer portion is at page 21, Lordship.
Yes.
Bottom line, Lordship, it is therefore prayer that decree may be passed for eviction of the plaintiffs from the scheduled land. that a decree be passed to put the defendant number 6 and 7 in position after recovery of scheduled land and removing all the obstruction of plaintiffs from there. That a permanent injunction may also be issued against the plaintiffs, their employees, etc., for making any obstruction, nuisance in respect of peaceful position of the lands set in the schedule, the cost of the counterclaim lordship, and any other reliefs. No prayer for declaration of right title interest with respect to the suit land in was prayed for by the defendant number 6 and 7, but the issue was framed, lordship.
So it is a pair number E, that any other relief, whether this will cover the right title and interest.
Prayer number E, lordship. My humble submission, lordship, declaration of right title interest is the should be prime prayer, lordship. In other reliefs, lordship, that may not be included, lordship. The other reliefs may not include the declaration of right title interest, lordship, because this declaration of right title interest is a prime prayer, and nature and character should be prayer for declaration of right title interest, lordship. In this case, lordship, they have neither prayed nor make any statement that they want right title interest in their plain, lordship. Moreover, lordship, second issue is second substantial question of law is that, lordship, whether in absence of any issue in regard to recovery of possession, the learned courts below committed error in decreeing the counterclaim for eviction of the plaintiff from the suit land. With respect to recovery of possession or eviction, lordship, no issue was framed by this trial court, neither by the trial court nor by the first appellate court, lordship. But
No, the decree is confined to the schedule of the counterclaim, not in respect of the entire plot of land.
yes,
Over
lordship.
the suit land is of 15 lesser.
Yes, lordship. Lordship, on earlier occasion, lordship, I prayed before this lordship to formulate additional substantial question of law. One of them, lordship, whether the learned court below committed error in determining an issue with respect to declaration of right title and interest of the counterclaimants over the suit land, which was not prayed in the counterclaim, and thereby deciding the aforesaid issue in favor of the counterclaimant. But honorable court observed that this issue, the substantial question of law number 1 will cover this issue. That's why no additional substantial question of law was formulated. So actually, that was another aspect with this substantial question of law. That lordship, the suit land was joint property of defendant number 1 to 5. But defendant number 1 alone sold the whole suit land, whole plot of land, whole schedule A land. There was 5 co-owner of the land, schedule A land, lordship, where schedule B is the suit land and part of the schedule A land. But the defendant number 1 solely sold the entire schedule A land to defendant number 6 and 7. That's why that substantial question may be formulated, lordship, that whether the learned court below committed error in decreeing title of the defendant number 6 and 7 over the whole plot of land. Also, as per section 44 of Transfer of Property Act, the one owner cannot sell the if they are, if the property is a joint property, one owner cannot sell whole part of the land, whole the land, lordship. That's why might have this issue as formulated, this question of law as formulated, lordship. But my humble submission, lordship, it is.
To decide this substantial question of law, whether this court is required to answer that question.
Substantial question of law number 1, lordship.
No. While dealing with this two substantial question of law, whether this court is required to answer that question.
Lordship, substantial question of law number 1, lordship. This, my humble submission, lordship, another substantial question of law may be formulated, lordship, additional substantial question of law regarding.
Yes, Mr. Decker. On the other day, you have of course submitted that there is no requirement of
Yes,
having
no
the
requirement.
substantial question.
Oh, my lord. Firstly, my lord, he has raised some question, my lord. Kindly see our WS, my lord. Please see WS, my lord. The WS filed by all the defendant, my lord, including 6 and 7, my lord. Joint WS, my lord, due to statement. So every amendment has been denied, my lord, regarding the adverse position. So, and by counterclaim by 6 and 7, another counterclaim by 6 and 7 for recovery position. So nobody has from the defendant side, my lord, the owner, nobody has raised that he has sold. There is nothing, my lord, because he can sold the property for on all behalf, my lord. He has admitted that the property belongs to the defendants, number 1 to 5, my lord. They have filed the written statement. They have not objected that our brother has been not authorized to sell the land, my lord. Never. No issue is there also, my lord. My lord, regarding my lord main point, he is claiming adverse position, my lord. Whether the ingredients are available or not, my lord. My lord, first they have to plead in their plain, my lord. Whether there is a adverse position. Now, my lord, from the plain, my lord, I sought, my lord. My lord, first they have in para 2, my lord, in pleading that during the lifetime of Saurabh Bhagwati, both the plaintiff who are the brothers on 11/11/94 entered into a plot of land measuring 15 acres to occupy the position which is the western portion of scheduled land, that is the suit land of this case, and more fully described in the Schedule B of the land. So in 2, my lord, there is no whisper regarding adverse position. Then, my lord, thereafter entering into position of the Schedule B suit land, the plaintiff developed the land by filing construction bounty over the issued land and stated about so and so, my lord. With the knowledge of Saurabh Bhagwati, mere knowledge, my lord, there is no hostile situation, my lord.
In paragraph number 14, they have stated.
They have stated hostility is there, my lord.
By way of adverse position.
When, my lord, there is date must be specific, my lord. From date of entry, there is no hostility, my lord. There is no hostility, no whisper, my lord, no evidence. That from that day, there is a quarrel, there is a police case, there is a overt act, nothing, my lord. So hostile, there must be specifically that in spite of the resistance, in spite of the objection, we have entered into the land, my lord. The hostile itself, literal meaning is sufficient, my lord. There is no hostility. He has that they residing in the nearby area, my lord. They never objected. So it cannot be hostile, my lord. It is permissive occupier. We have specifically pleaded, my lord. Actually, below 11/11/94, the date of possession is the artificial date method to cater the 12 years method. In fact, they entered in the 2006 method. Prior to that, Gumti was in different place of different person method. In their evidence, it is clearly stated method that Gumti was in different place method. Issue is particularly issue Millard regarding the issue number 3. This is the main issue Millard that was decided by the trial court rightly and affirmed by the appellate court Millard. The possession, whether it is adverse possession or permissive possession Millard, is a finding of fact Millard. That is decided by concurrently. That this is not hostile possession, this is not adverse possession. Now Millard saying that on president of the so-and-so Bebhai Santha, he personally visited. Where is the DAG number, pattern number? When revenue authority record is also assailed by the parties Millard. Now here is the one president Millard. He has stated that I have seen. Where he has seen Millard, which DAG number, pattern number, what is the status of the nothing Millard. And particularly it is also dealt with by the trial court that at the 11th time, the Baska was not a district Millard, but in the particular exhibit, the certificate, the heading is the Kamrup, Nalbar district and Baska district Millard. It is clearly stated Millard, and from the Millard, Baska district is not in existence during that period Millard. That is clearly stated Millard. Actually, my lord, trial court also finding that it was not relevant. Google from the melody 2003 Baskar was created, my lord. Although this fact is not evidence, but it is finding of the trial court, my lord. That already I have stated that the PW3 in cross Bhonita Rafar Matit Badit Gumti Ata Ase. So it is clear, my lord. We have stated that there is a Gumti in the land of this Gumti was originally Bhonita Rafar's land. And their witness clearly stated, my lord. This is the fact, my lord. And it is accepted by the Bodha court, my lord. Then in cross also she stated Baba Bandar Dokan Khon 2006 sonot bonoa ne nai moi najano. So there's no knowledge. This certificate of the Bebhai Santha is not very reliable, my lord. Because they have falsely stated that there is a Gumti. Nothing.
But this coming to this first substantial question of law. In absence of any pair in the counterclaim,
Yes, madam.
that is a substantive pair, right
Pair-
title and interest.
Right title,
Without such a pair being made in the counterclaim, can the court decree the suit?
yes, my lord, because they have stated there is a sale deed, my lord. They have admitted that the plaintiff number, defendant number 1 to 5 are the owner, my lord. They have right title interest. And his solely property by way of registered sale deed. His name is mutated. The defendant 6 and 5 name was mutated, my lord. So title is there, my lord. Regarding possession, my lord.
Again, you are coming to the fact, I am on law point.
Yes, my lord. It can be, my lord, because in WS they have denied his title, my lord, by way of birth position. Now, if his suit is dismissed, my lord, what relief we get? How will we enter, my lord? That is why we have prayed for recovery of possession, my lord, and injunction, so that again he cannot. There is injunction also, my lord, purposeful injunction. So it can be, my lord. So there is no necessity for, again, he has to prayer for declaration of right title interest. Moment his right title is extinguished, my lord, it becomes to the owner, my lord. For claiming adverse position, there must be some owner, my lord. He has admitted that they are the owner, my lord. And I am I purchased the land by legally purchased the land, only possession, my lord. And he has stated, the evidence is there, my lord. On the date of possession, symbolic possession, my lord, he has stated he has took time, my lord, for vacating the land, my lord. So there is no question of the requirement of the declaration of right title in again, my lord.
No, they have prayed for time for vacation, or is there any material also?
Yes, they have stated. They have stated that we want some time, my lord. And till, my lord, instead of the suit.
Where they have stated?
Our evidence is there, my lord. Evidence clear, son. Let's see this. My lord, I'm reading the chief first, my lord. বিরোধী পট্টা কালজাৰ গাঁৱৰ চোৱাঞ্চো পট্টাৰ ইমান ডাঙৰ উক্ত জমি খণ্ডক লৈ একে পট্টাৰ একে ডাগৰ এক সংলগ্ন আৰু দুই কথা 5 লাখ সমুদায় I'm reading the defendant number 2, my lord. PW2, DW2. DW2.
DW2.
DW2, but so I can read from DW1, my lord. One also the same thing, my lord.
Okay.
বিরোধী জমিখণ্ড পূৰ্বতে আমাৰ অধুনামিত পিতা শৰৎ চন্দ্ৰ ভাগৱতীৰ নামে স্বত্ব দখলৰ জমি আছিল। বিরোধী জমিখণ্ডৰ পৰিমাণ 15 লাখ। উক্ত জমিখণ্ড কালাজাৰ গাঁও ফেৰাজমেলি 322 নম্বৰ পট্টাৰ 961 নম্বৰ ডাগৰ 10 লাখ আৰু উক্ত ডাগৰৰ 305 নম্বৰ পট্টাৰ 962 নম্বৰ ডাগৰ এক সংলগ্ন 5 লাখ জমি হয়। উক্ত জমিৰ চোৱাত চোৱাঞ্চো উক্ত গোচৰৰ বাদীদ্বয় মোৰ মৃত দেউতা দূৰ সম্পৰ্কীয় লোক হয়। মোৰ দেউতা বাৰ্ধক্যজনিত অসুখৰ বাবে বিছনাৰ মৃত্যুৰ আগলৈ কেইবছৰ পৰি আছিল। 1 নং বাদী 2006 চনত চাকৰিৰ পৰা অৱসৰ লৈ নিজ ঘৰলৈ আহিছিল আৰু উক্ত চনত কোনো এদিন উক্ত বাদী দেউতাৰ ওচৰলৈ আহি দেউতাৰ নামত থকা বিৰোধী দুখন পট্টাৰে 15 লাখ মাটিত তেওঁলোকৰ কিছু আঁতৰত থকা বাবা ভাণ্ডাৰ নামৰ দোকানখন স্থানান্তৰিত কৰাৰ বাবে অনুমতি বিচাৰিছিল। তেতিয়া দেউতাই 2-3 বছৰৰ বাবে অনুমতি দিছিল আৰু যেতিয়া তেওঁ অথবা তেওঁৰ উত্তৰেৰে উক্ত জমিখণ্ড বিচাৰিব তেতিয়া উক্ত জমিখণ্ডৰ পৰা বাবা ভাণ্ডাৰ নামৰ দোকানখন আকৌ স্থানান্তৰিত কৰিব লাগিব বুলি কৈছিল। আনহাতে বাদীয়ে তেনেদৰে চলিম বুলি আমাৰ ঘৰতে দেউতাৰ আগত অংগীকাৰ কৰিছিল। উক্ত সময়ত মোৰ বন্ধু প্ৰতিবিদ্যুত আন 2-4জন লোক উপস্থিত আছিল। প্ৰতিবিদ্যুত উক্ত কথাখিনি সেইদিনাই মোক ফোনযোগে জনাইছিল। তেতিয়া মই উক্ত দেউতাৰ ওচৰলৈ কোনো কথা নকওঁ বুলি কৈছিল আৰু তেতিয়াৰ পৰা উক্ত বাবা ভাণ্ডাৰ নামৰ দোকানখন বৰ্তমানে বিৰোধী জমিত চলি আছে। আমাৰ দেউতাৰ 2007 চনৰ 27 ছেপ্টেম্বৰত মৃত্যু ঘটে। দেউতাৰ মৃত্যুৰ পিছতে বিৰোধী পত্ৰৰ বিৰোধী জমি খণ্ডক লৈ একেলগে 2 কঠা 5 লেচা সৰ্বমুঠ 3 কঠা জমি শপতকাৰীয়ে এই বছৰৰ 6 আৰু 7 নং বিবাদী বছৰ 2011 চনত বিক্ৰী কৰিম বুলি কৈ উক্ত বাদীদক তেওঁলোকৰ দোকানখন উক্ত জমিৰ পৰা অন্য ঠাইলৈ উঠাই নিয়াৰ বাবে কোৱাত সন্মতিও মোৰ আগত প্ৰকাশ কৰিছিল। সেইমতে মই শপতকাৰীয়ে দলিল ৰেজিষ্টাৰ কৰাৰ আগতে যাৱতীয় অনুমতি পত্ৰ আদি পোৱাৰ পিছত 10/2/2011 ইংৰাজী তাৰিখে 6 আৰু 7 নম্বৰ বিবাদী বছৰত 3 কঠা জমি নিমিত্তে বিক্ৰী দলিল সম্পাদন কৰি দিওঁ। তাৰপিছত 12/2/2011 তাৰিখে গাঁৱৰ মানুহৰ সাক্ষাতত উক্ত জমিখণ্ডৰ দখল ক্ৰেতাদ্বয়ক চমজি দিছিলোঁ আৰু সেইদিনাখনে বাদীদ্বয়ে তেওঁলোকৰ দোকানখন বিবাদী জমিৰ পৰা অনতিপলমে স্থানিত কৰিম বুলি প্ৰকাশ্যে সকলৰ আগত প্ৰকাশ কৰিছিল। তাৰ পিছতে উক্ত ক্ৰেতাদ্বয়ে উক্ত জমিখণ্ডৰ ৰেজিষ্টাৰ দলিল মূলে নামজাৰি আদি কৰি লৈ চনৰ ৰাজহ ইত্যাদি আদায় কৰি বিপৰীত 15 লেচা জমিৰ বাহিৰে বাকী অংশত জমি ভূ দখল কৰি আছে। বাদীদ্বয়ে 2094 চনৰ 11 নৱেম্বৰ দিনাখনৰ পৰা উক্ত বিৰোধী জমিখণ্ডৰ ভোগ দখল কৰি থকা কথাটো শপতকাৰী সত্য বুলি স্বীকাৰ নকৰে। সেই উক্ত জমিখণ্ডৰ ওপৰত বাদীদ্বয়ৰ এডভাৰ্চনৰ দাবী বহুত মিছা। উক্ত বছৰৰ 6 আৰু 7 নম্বৰ বিবাদী দখল কৰা বনৰ লগত পাল্টা দাবী যোগে বাদীদ্বয়ক বিৰোধী জমিৰ পৰা উচ্ছেদ কৰাৰ বাবে মানুহলৈ আজি দাখিল কৰিছে। So he is the chief melot and similar chief is given by the PW2 also. In cross melot, বিবাদীয় মাটিটো মৃত ডক্টৰ শৰৎ ভাগৱতীৰ নামত আছিল। এইটো সত্য নে যে বাদীয়ে
Cross examination of DW2.
DW1 melot.
One.
DW1.
Okay.
The final thing is not good melot. বাদীদ্বয় মোৰ
দেউতাৰ দূৰ সম্পৰ্কীয় নহয়।
বাদীৰ মোৰ দূৰসম্পৰ্কীয় নহয় আৰু সেইবাবে মই সম্পৰ্ক উল্লেখ কৰিব পৰা নাই। বাবা ভাণ্ডাৰ এইটো সত্য নহয় যে দিছ ইজ চাইজন বাবা ভাণ্ডাৰখন ক'ত আছিল মোৰ সাক্ষ্যত উল্লেখ কৰা নাই। কোন তাৰিখে মোৰ দেউতাই বাদীক দোকানখন পাতিব অনুমতিছিল মোৰ সাক্ষ্যত উল্লেখ নাই। মই পত্ৰ শপত 2 নম্বৰ পেৰাগ্ৰাফত উল্লেখ কৰা কথাবোৰ মোৰ বৰ্ণনাত উল্লেখ কৰা নাই। মোৰ পত্ৰ শপত 3 নম্বৰ পেৰাগ্ৰাফত উল্লেখ কৰা 1 নম্বৰ আৰু 5 নম্বৰ শাৰীত থকা কথাখিনি মোৰ বৰ্ণনাত উল্লেখ নাই। মোৰ আৰু এজন
আৰু এজন ল'ৰা দেউতাৰ আছে।
দেউতাৰ আছে। মোৰ ভনী দুজনী আৰু দেউতাৰ মৃত্যুৰ পিছত বিবাদীয় জমাটি মোৰ মা আৰু আমাৰ ভাই ভনীৰ মাজত উটাই গুটাই আহে। আমাৰ পৈতৃক সম্পত্তি লিগেল পাৰ্টিশ্যন আমাৰ মাজত হৈছে নে এইটো?
উত্তৰাধিকাৰৰ মাজত হৈছে।
লিগেল পাৰ্টিশ্যন হোৱা ডকুমেণ্ট মই এই আদালত দাখিল দিয়া নাই। এই গছৰে মাটিটো মই here is melot. We have not filed any document, but they have not denied that it is not partition melot. We have stated in clause that there is a partition, family partition melot. We have not filed any document. So they have not said that there is no partition melot. Now they have raised that there is partition. That is not question melot out of our গছৰ মাটিটো মই অকলে বিক্ৰী কৰা বুলি দাবী কৰিছো। মই বিবাদীয় মাটি বিক্ৰী কৰাৰ সময়ত বাদীদ্বয়ৰ দোকান এখন আছিল।
এই মাটিতে আছিল।
বাদীদ্বয়ক মাটি বিক্ৰী কৰাৰ আগতে কোনো নটিচ দিয়া নাই। মই মাটি বিক্ৰী কৰি চিম্বলিক পজিশ্যন দিছিলো। মোৰ সাক্ষ্যত কৰাৰ সময়ত তাৰ সাক্ষাতত দখল দিছিলো। তেওঁলোকৰ নাম উল্লেখ কৰা নাই। এইটো সত্য নহয় যে পৈতৃক সম্পত্তি সকলে বিক্ৰী কৰাৰ অধিকাৰ মোৰ নাই। Please question can asked by the co-owner, not by him, whether we can sell or not. বাদীদ্বয় বিবাদীয় মাটি 2006 চনত থকাত মই লিখিত প্ৰমাণ দাখিল কৰা নাই। এইটো সত্য নহয় যে মই বাদীদ্বয় কোনো এছ'চিয়েশ্যনৰ পৰা বিবাদী মাটিত দোকান দি আছে। বাদীদ্বয় বিবাদী মাটিত দোকান কৰি থকা মই 2004 চনৰ পৰা দেখিছোঁ। মোৰ দেউতাৰ পৰা বাদীদ্বয় বিবাদীয় মাটিত দোকান দিবৰ অনুমতি পোৱাৰ কোনো লিখিত প্ৰমাণ নাই। এই অনুমতি মৌখিক হৈছিল। অনুমতি দিয়াৰ তাৰিখ মই ক'ব নোৱাৰিম। বাদীদ্বয়ক দোকান দি থকা দেখিও মই উচ্ছেদ ব্যৱস্থা লোৱা নাছিলোঁ। মৌখিকভাৱে কোৱা হৈছিল। মৌখিকে কোৱা কথাটো মই প্ৰদীপ দত্তৰ পৰা শুনিছোঁ কাৰণ মই সময় উপস্থিত নাছিলোঁ। এইটো সত্য নহয় যে চাকৰি সংক্ৰান্তত আছেনে তাতে?
আছে আছে। চাকৰি সংক্ৰান্তত বাহিৰত থকা বাবে গোচৰ সংক্ৰান্তত মোৰ ব্যক্তিগত জ্ঞান নাই।
Yes, then who also similar version Melot? কিনাৰ পিছত মাটিটো ফিজিকেল পজিশ্যন মোক দিয়াব পৰা নাই। মই দখল লৈছিল তেওঁলোকৰ নাম উল্লেখ কৰিব পৰা নাই। So Melot, here in the SIP Melot we have stated that we are the owner Melot. They have not cross-examined, they have not denied or said that the land is not of Mr. Bhagopati. So they have not denied. So title is in the defendant number 1 to 5, and they have by register just sold to the defendant number 5 and 6. So there is no necessity to, my lord, for raise declaration of right title. There is not necessary, my lord, because it is title is in the defendant number 1 to 5 million in their favor, my lord, and they sold by way of regular register sale deed. So again, it is not necessary. If they said that this sale deed is void, my lord, then we have to counter that. It is not void, my lord. They have not raised that it is void. And this, whether that issue is necessary or not, they have to raise, my lord, at that time of trial as well as the first appellate court. They have not raised it in the trial court that these issues should be framed, my lord. And it is covered. When issues are clear and, my lord, it is covered all the fact admitted or denied, my lord. The burden, my lord, lies upon the plaintiff to establish his main case, my lord, adverse position. He has miserable frail, my lord. The starting point of adverse position, they have not stated. They have possession, even if they are admitted that they are in since 1994. Mere long possession cannot be adverse, my lord. By itself, it's not. They must specifically pleaded in the plaint, and to that effect, they have to adduce evidence, my lord. They have not specifically pleaded that their position on the right from 11/11/1994, it is adverse, my lord. Only they enter adverse, no objection, nothing, my lord. And
No, they have pleaded in the plaint and also in their evidence. But
Part adverse is there.
hostility part.
Hostility part, my lord. Hostile, there we have not objected. They have stated that no objection. We are residing near. All along there, no hostility is there, my lord. Permissive occupier. How a person, my lord, can possessing and constructing land without our permission nearby our resident, my lord? He cannot, my lord. And if there is any hostility, we will have to file. We will file a case and obstructed his, my lord, position, my lord. There is nothing. Though that point is not there, my lord. So it is, my lord, right from, my lord, 1964, it is clearly stated that to plead adverse position, all ingredients must be there, my lord. It is this main point is absent, my lord. Hostility or hostility, my lord. Mere using that we have perfected adverse position, it will not do, my lord. They will clearly stated. They have to clearly stated that their position is adverse. And in during that period, they have never tried to mutate their name by want to pay the revenue in their name. Nothing, my lord. No, nothing has been done, my lord. So their plea from permissive occupier to the adverse position is not sustainable, my lord. And, my lord, the point, my lord, 2006 and 2011, 11, my lord, it is disputed, my lord, because 94 and 2006, my lord. If 2006 They are possessing 2006, even if it is a hostile, that is also not ripened in 2011, my lord. 12 years minimum is required, my lord. But if 2011, my lord, 2011, 1994, my lord, 1994 it is not, my lord, there is no any hostility or no any ingredients of purpose from 1994, my lord. And but it is not believable where a person is serving as army, my lord, till 2006, and he is possessing into 1994, my lord. It is not believable. And he is in army in the Manipur or sub area, my lord. This story, my lord. He could not prove, my lord. And the document they have stated only 2006, my lord. The electricity and insurance is 2011, my lord. The documentary evidence also not supporting the defendant, plaintiff, my lord. Look, I have given a list of documents regarding the adverse position, my lord. My lord, the 2010 Supreme Court, it is clearly stated, my lord, in para 11, my lord. Regarding the adverse position, my lord. May I read, my lord, para 11, 2000. 2004, 10, SCC 779. 11, my lord, para 11. In the eye of law, an owner would be deemed to be possession of a property so long as there is no institution, no use of property by the owner even for a long time would not affect his title. But the possession will be altered when another person takes possession of the property and assert a right over it. Adverse possession is a hostile possession by clearly asserting hostile title in denial of the title of the true owner. It is a well-settled principle that a party claiming adverse possession must prove the possession is nec v, nec claim, nec pursuit. That is peaceful, open, continuous. The possession must be educated in continuity, in publicity, and in extent of so that their possession is adverse to the true owner. It must start with a wrongful disposition of the rightful owner and be actual, visible, exclusive, hostile, and continued over the statutory period. It is relied some other judgment, my lord. Physical facts of exclusion position and the animus proceeding to hold as owner in exclusion to the actual owner are the most important factors that are to be accounted in case of dismissal. Plea of adverse position is not a pure question of law, but a blended one of the fact and law. Therefore, a person who claims adverse position should show on that date on what date he came into position, what was the nature of his position, whether the factum of position was known to the other party, how long his position has continued, and his position open and undisturbed. A person pleading adverse position has no equities in his favor, since he is trying to defeat the right of the true owner. It is for him to clearly plead and establish all facts necessary to establish his adverse position. So, my lord, clearly stated, first he have to plead, my lord. Pleading must be clear, my lord. There is an adverse position from so and so that, my lord. That is clearly absent. Subsequently, evidence is also required, my lord. That is also not clearly established by the plaintiff, my lord. My lord, regarding issue, my lord, timing of issue. My lord, I am relied upon the judgment in 2005, my lord. 2005, AR 2005, 2392. My lord, it's para 44. No doubt, no issue was, in so and so, it was observed. No doubt, no issue was framed, and the one which was framed could have been more elaborate. But since the parties went to trial fully knowing the rival case and laid all the evidence not only in support of their contention, but in the reputation of those of the other side, it cannot be said that the absence of an issue was fatal to the case, or that there was that mistrial which featured the proceeding. We are therefore of the opinion that the suit could not be dismissed on this narrow ground, and also that there is no need for a remedy, as the evidence which has been laid in the case is sufficient to reach the right conclusion. Neither party claimed before us it had any further evidence to offer. So, my lord, we have in the counterclaim, we have filed a plain, my lord. In that plain, they have filed a written statement made up by the plaintiff, my lord. So it is clear that what is the case, my lord, and what is the issue as framed, my lord, and what evidence is to be required to be laid, my lord. They have laid evidence, my lord. We have also laid evidence. Both party knows that they want to recover a position and they recover a position of particular land on the basis of their title inherited from their vendor, my lord. So there is no necessity for declaration of right. And regarding other land, they have already admitted that vendor is all land is inherited from their father, miller, and part of only 15 lessons are sold to the defendant number 5 and 6, miller, and therefore the recovery position is necessary because they have denied, although they have admitted that we are relinquish as and when required, miller. So it is only recovery position. There is no question of any title and not required to frame any issue. Already both parties knows that this is the this, miller.
Yes, any other point?
My lord, another ruling, my lord, recent judgment, my lord, 2024, Justice O. Asoka and Ujjwal Bhai, my lord, it is, my lord, 2024 AR, Supreme Court 1595, my lord.
Paragraph number?
Paragraph number 12, my lord. Therefore, to prove the plea of adverse person, the plaintiff must plead and prove, my lord. First, there must be pleading, my lord. Thereafter, he have to prove, my lord. The plaintiff must plead and prove that he was claiming possession adverse to the true owner. B, the plaintiff must be plead and establish that the factum of his long and continuous possession was known to the true owner. The plaintiff must also plead and establish when he came into possession. The plaintiff must establish that his possession was open and undisturbed. It is settled law that by pleading adverse possession, a party seeks to defeat the right of the true owner, and therefore there is no equity. So it is borrowed from that judgment, my lord. Earlier judgment I have read it. Just read it. Equity in his favor. After all, the plea is based upon the continuous wrongful possession for a prior period of more than 12 years. Therefore, the fact of continuing the ingredients of adverse possession, constituting the ingredients of adverse possession, must be pleaded and proved by the plaintiff. Then para 16, my lord.
Okay, is it necessary to multiply the decision?
No, not necessary, my lord. Already it is clear, man. I established that your lordship also aware of all these things, my lord, because your question reflect that, my lord.
Yes, Mr. Soma, anything to submit?
Lordship, with respect to the declaration right title interest, whether it is required or not, Lordship. Lordship, we admitted that defendant number 1 to 5 is the original owner, real owner. We have admitted their ownership. Thereafter, defendant number 1 solely sold the suit land to defendant number 6 and 7, but could not deliver it the possession that has been admitted by the defendant side. Accordingly, Lordship, their title has been clouded. As because they could not take the possession of the till that they are not in possession of the suit land. They have just entered into a sale deed. And we have also challenged the sale deed in our prayer portion, Lordship. That's why, accordingly, Lordship, the title of the defendant number 6 and 7 is clouded. So therefore, my humble submission, Lordship, it is essential to declare the right title interest. It is essential their declaration of right title interest, Lordship, but that was not pleaded, Lordship. Even though the learned trial court framed an issue and decided it, Lordship. Moreover, Lordship, Order 7, Rule 7 CPC says, Lordship, relief to be specifically stated, Lordship. Every plain shall state specifically the relief which the plaintiff claims either simply or in alternative. And it shall not be necessary to ask for general or other relief which may always be given as the court may think, thus to same extent as if had been asked for, and the same shall apply to relief claimed by the defendant in his written statement. Lordship, in the counterclaim of filed by the defendant 7, no stand has been whether has been stated by the learned senior counsel for the respondent. No stand has been taken that we are in possession since 2006. Our land was at another place. No, in counterclaim, no statement has been stated by the counterclaimant. Counterclaimant has also stated that we bought the suit land from plaintiff. So we have prayed for eviction, Lordship. Lordship, in this regard, may I submit? It is 2020 to 1 SCC 115. Okay. Lordship, in 2022 1 SCC 115, Lordship, at page 124.
Yes.
It has been held by the Honorable Apex Court that it is fundamental that in a civil suit, relief to be granted can be only with reference to the prayers made in the pleadings. That apart, in civil suits, grants of relief is circumscribed by various factors like court fee limitation parties to the suit, as also grounds bearing relief like res judicata, estoppel, acquiescence, non-joinder of cause of action parties, etc., which require pleading and proof. Therefore, it would be hazardous to hold that in a civil suit, whatever be the relief that is prayed, the court can, on examination of facts, grant any relief as it thinks fit. In a suit for recovery of rupees 1 lakh, the court cannot grant a decree of rupees 10 lakh. In a suit for recovery of possession of property A, court cannot grant possession of property B. In this case, Lordship, case is not for declaration of right title interest, but the learned trial court declared right title interest of the.
But the sale deed has not been challenged.
Challenged, Lordship.
Where?
In our plaint, Lordship, cancellation of sale deed. We have made prayer, Lordship. Lordship, at Lordship, at page 11 of the appeal memo, Lordship. Lordship, prayer number 3. The cell deed number 8/11 dated 10/2/2011, registered at Mosolpur Sub Registry Office, is liable to be cancelled and issue precept to note cancellation of the said cell deed number so and so, so and so. And we also stated in our plain regarding this details of this cell deed, Lordship. To my humble submission, the learned trial court committed error in declaring the right title interest of the suit land in favor of the counterclaimant number 6 and 7, Lordship. Lordship, here is another substantial question of law, Lordship. Yeah, question. Substantial question of law number 2, Lordship. Whether in absence of any issue in regard to recovery of possession, the learned court below committed error in decreeing the counterclaim for eviction of the plaintiffs from the suit land. No issue was framed, Lordship, regarding recovery of possession by the counterclaimant, but that was decided by the Honorable Court without framing any issue, Lordship. If your Lordship kindly already gone through the Lordship has gone through the issues, no issues were framed with respect to the recovery of possession, Lordship. And without any reason, without explaining sufficiently, Lordship, the learned trial court.
Maybe how appellate court has dealt with the issue?
No, Lordship. Learned appellate court did not change any issue, Lordship. He discussed the issue which were already framed in the trial court, Lordship. May I submit one citation, Lordship? 2018 11 SCC 653. This decision also related to a substantial question of law number 1, Lordship.
So the appellate court has not framed, not formulated any point for determination in the judgment.
Not other point, Lordship. The learned trial court only discussed the judgment of the trial court, Lordship. The issue framed by the learned trial court is at page 65, Lordship. Same issues, Lordship.
The point for decision is here, the fighting points. Para 11.
No, even though the appellate court has not formulated any point for determination, yet if it discussed the
It's 11, my
issues
lord.
in the judgment, then it is not fatal.
Yes, my lord, it is 11. The vital point to be determined in this appeal is whether the plaintiff have been possessing the suit land for more than 12 years against the interest of the defendant, whether the plaintiff have acquired right title interest over the suit land by adverse possession
Regarding plaintiff lordship.
regarding plaintiff.
On other aspects, lordship, sir,
So, my lord, if his suit is dismissed, my lord, and if my suit is also who will possess, he will possess the land, my lord. If he is not, he has denied that he has not permissible occupier, and his claim of adverse possession is dismissed, my lord. Then till then he is possessing, my lord, without any recovery possession, my lord. So, my lord, entirely related, my lord. If his title is denied by the court, definitely relief, more any other relief prayer is there, my lord. This is the relief, my lord, to the parties, and we are claiming counter by way of counter claim, my lord. And this point is vital point is decided by the appellate court also. Point for decision is there.
lordship, another aspect is that we had prayed for declaration of right title interest, lordship, in our claim, but no issue was framed regarding this, lordship. The issue is the main problem, lordship, in this case. They did not pray for declaration of right title interest, but that was decreed, lordship. We prayed for declaration of right title interest, but no issue was framed regarding that.
No, this issue number 4 was framed. Whether the defendant has a right title and interest over the suit land as averred in the counterclaim. While discussing this issue, the trial court has also discussed your right title and interest also.
But learned trial court or first appellate court not framed any issue with respect to our declaration of our prayer of declaration of right title interest.
Not necessary. This issue number 4 will cover it.
Lordship, my little knowledge, lordship, after framing a new issue, lordship, it is necessary to give opportunity to both the parties to adduce evidence, lordship. But no scope was given, lordship.
But this court has to confine only to the substantial question of law.
Lordship, that's why, lordship, I humbly submitted, lordship, to formulate another substantial question of law, lordship, that whether learned trial court as well as first appellate court committed error and not framing issue with respect to my declaration of right title interest, lordship, and already formulated substantial question of law number 2, lordship. No issue was, lordship, no issue was framed with respect to recovery of position, lordship. But honorable court passed a decree for recovery of position, lordship. Neither in the trial court, learned trial court, neither by the first appellate court, issue was framed with respect to recovery of position, lordship. But both the learned courts below decided in favor of the counterclaimant, lordship.
Oh, here the main issue is only the adverse position.
Lordship, but no substantial question of law with respect to adverse position was, lordship, and lordship.
So this a substantial question of law will cover, I think.
Lordship, my humble submission is that, Lordship, Lordship, as no issue was framed and not, it has been elaborated by the both the courts below, Lordship, how recovery of possession with respect to the suit plan may be granted to the counterclaimant. Just in two sentences, Lordship.
No, not necessary. If the appellate court directed a discussion to that effect and arrived at a finding, then non-framing, non-formulation of any point for determination would not be fatal. There is a
Lordship,
recent decision of Supreme Court in the case of Mugendro Indravan Mehta
yes,
versus a municipality, Gujarat Municipality Corporation, or like that. Mugendo Indravan Mehta versus a Gujarat Municipal Corporation, or like that. The other party. There, Supreme Court has stated.
the learned court below, Lordship did not discuss regarding how recovery of possession may be granted to the counterclaimant, Lordship. And moreover, Lordship, the learned trial court as well as the learned appellate court only discuss with the cross-examination part of the plaintiff's, Lordship. But both the court did not discuss the cross-examination part as well as evidence part of the defendant side, Lordship. In the cross-examination of the defendant's, Lordship,
Why there is necessity while some of the facts are admitted?
Lordship. But moreover, Lordship, they have admitted various things which makes any confusion.
Okay. Do you have any other point to submit in respect of these two substantial question of law or not?
These two substantial question of law, I have nothing, no more submission.
Nothing.
Just is this one.
Then we'll close the matter here.
Lordship, my more humble submission, another humble submission, Lordship. As per Order 41, Rule 25, Lordship.
Order?
Order 41, Rule 25, Lordship. Where appellate court may frame issue and refer them for trial to court whose decree appealed from. Where the court from whose decree the appeal is preferred has omitted to frame or try any issue or to determine any question of fact, which appears to the appellate court essential to the right decision of the suit upon the merits, the appellate court may, if necessary, frame issues and refer the same for trial to the court from whose decree the appeal is preferred. And in such case shall direct such court to take an additional evidence if required. My humble submission is that this is a fit case to remand, Lordship. After framing a new issue, Lordship, and to give opportunity to adduce evidence to both the parties, Lordship. As because it has also not been, no issue was framed with respect to our pleading also, Lordship. We pleaded declaration of right title interest, Lordship, but no issue was framed, Lordship. We did not have any opportunity to adduce evidence with respect to that issue, Lordship. As no issue was framed, Lordship, already. My humble submission, Honorable Court may remand the case to try for after framing a issue, Lordship, with respect to recovery of possession.
Okay. The second appeal is on the basis of the substantial question of law, and substantial question of formulated on the basis of the memo of appeal, the ground of appeal, the ground of appeal as dear melon for framing a additional issue. They have not made any ground melon here. So the framing of substantial question is not a substantial question law melon. Framing of an issue is not a substantial question of law melon, because it must be pleaded in their appeal memo. There is nothing there.
Heard, sir. U.P. Sharma, learned counsel for the appellant, and Mr. P.S. Decker, learned senior counsel assisted by Ms. Uzagura.
Yes.
Learned counsel for the respondent. Argument concluded, judgment is
Highly obliged, sir.
Red herring, 5, 6, and 22.
Five, six, or three. I am for 22, my lord. Here, my lord,
Who is, Mr. Khandekar, please sit down. Let the first 5 and 6 come.
Yes, ma'am.
Item number 5 and 6.
In this case, Mr. Surojit Das will appear. Okay. He
Who?
is coming. He is coming. Lord. He was there, but
Okay, then Mr. Khandekar, please.
right.
So issue is the same.
Issue
There's,
is the
non-compliance
same.
of the
Issue is same, my lord, and I like to place some, our coordinate bench of our court, my lord, as per some order. Where, my lord, accused person was arrested on 9/4/2023, prior to Pankaj Bansal. Bail has been granted, and it has been discussed. Learned PP also
No,
told.
maybe whether the decision of that Aurora,
Yes.
whether that was pointed out to the learned court.
That I am.
Then I have also granted bail in 2 cases.
My lord.
But at that point of time, that decision was not referred by the additional PP.
Arora, my lord, Ram Kishore Arora.
Ramkishore Arora, yes.
That is also discussed, my lord.
Where?
In my lord here.
After discussing that.
After learned PP has submitted this judgment, but the honorable court said that these are not relevant. I am having it. Everything discussed, even my lord, the chief secretary is also requested to take necessary action against the arresting authority who have committed the mistake.
Maybe that is a different aspect.
Yes, my lord.
Our question is whether the decision of Bihan Kumar,
yes,
Pankaj Bansal, and Ramkishore can be given a retrospective effect.
Yes, my lord. That was the submission.
So apart from this coordinate bench decision, do you have any other decision?
I have also another judgment, my lord, another order, my lord.
Of
BA number 121/2000.
Of which court?
Of Honorable Justice Mitali Thakuria. One is Justice Mitali Thakuria and another is.
No. I'm not telling about you of this court, of other high court or Supreme Court.
And in fact, my lord, my case is today, for today. Motion is.
Some coordinate bench observed that.
Observed that in Ram Krishna
In view
Arora.
of the decision in Ramkishore Arora, bail cannot be granted.
Bail is granted. It has
No.
no relevance.
No, by some of the coordinate bench observed that.
I am not having.
You are not aware. That decision is available with him.
Then, my lord, in some other court, High Court, my lord, but now we are having the decision of our High Court, my lord.
So here the opinions are divergent. Some coordinate bench accepted the submission of the council, and some coordinate bench accepted the submission of the additional PP.
But kindly look at this, my lord. My lord, I don't know whether my lord have gone through this or not. I'm having, my lord. It will do. My lord, kindly pay this. Elaborate discussion has been made. After all, my lord, we are on the constitutional provision, my lord. We are on the constitutional provision, my lord.
No, that's all right. Everything was fine, but they say Ramkishore Arora.
Yes, my lord. So paragraph 5.1, my lord. My lord, kindly peruse for a moment. He further submits the judgment and order of the apex court in the case of Pankaj Bansal versus State Union of India and others reported in so and so. And Bihan Kumar Supra shall apply prospectively, and therefore the same is not applicable in the fact of the present case. This is the submission of the PP, land PP, my lord.
So what is the finding?
Now finding, my lord. Then, my lord, paragraph 29. Paragraph 29, my lord. Furthermore, the argument of Mr. Kaushik, learned additional public prosecutor Assam is to effect that the judgment and order of the apex court in the case of Pankaj Bansal Supra is prospective, is of no relevance in the facts and circumstances of the instance case, inasmuch it is not the contention of the accused prisoner that the arrest is vitiated for that communicating the grounds of arrest in writing. That apart, all the case laws cited by Mr. Kaushik, learned additional public prosecutor, have received due consideration from this court. However, the same are not applicable in the fact and in the instance. Hence, the case no relevance. It has been decided. It is pronounced on, my lord, 2/5, very recent, 2/5/25.
Yes.
So everything has been discussed. What remains, my lord? All the judgments produced by the learned additional PP has been considered and stated no relevance. Why, my lord, these cases are pending? My lord?
My lord, regarding the, my lord, earlier argument, and I also pointed out to your lordship regarding to coordinate bench's judgment regarding prospective effect of the, my lord, Pankaj Bansal's judgment, my lord, without going into all these judgments, while Pankaj Bansal judgment itself stated that this, by using the word henceforth, where, my lord, there is no other, my lord, argument will be required to support that contention, my lord. Pankaj Bansal itself, while, my lord, stated by using that word henceforth, and which was strengthened by other judgments, there was, my lord, otherwise, my lord, after that judgment, my lord, there is no other judgment, my lord, required for supporting that contention, my lord. That itself is sufficient, my lord. While that judgment itself said by using the word henceforth, that is sufficient. No other judgment will be required to, my lord, strengthen that case, my lord. And thereafter, although by Ramkishore Arora, and my lord, I would also like to point out, although I am not going into all those arguments right now, my lord, because my argument is right now limited to prospective effect, because these cases are, my lord, arrest before 310. But however, if I am going to argue, my lord, from the, my lord, that Ramkishore Arora's argument, your lordship, the present earlier also pointed out one, my lord, constitutional bench judgment, my lord, Hari Kishan Agarwal, and my lord, there is in Ramkishore Arora's judgment, my lord, one, my lord, constitutional bench judgment. I would just like to point out here.
Why not, my lord? This is our judgment, our High Court judgment. It should get priority.
One, my lord, one constitutional bench judgment which was discussed in my lord, Ramkishore Arora's case, Bijoy Madan Lal Chaudhary. That is the constitutional bench judgment, and according to that constitutional judgment, only it is required to my lord, inform about the grounds of arrest to the accused person. But there is no such requirement of, my lord, furnishing grounds of arrest in writing. Thereafter, while that constitutional judgment is still holding the field, thereafter, my lord, these judgments, Pankaj Bansal, my lord, thereafter, Prabir Purukayastha, and on the basis of here in Bihan Kumar's judgment, my lord, everywhere discussion is about Pankaj Bansal, and I am not disputing, my lord, regarding some of the constitutional provisions. But what happened in Pankaj Bansal, Prabir Purukayastha, and thereafter discussing all those judgments, Bihan Kumar's judgment, my lord, Bihan Kumar also, it's in the conclusion is specifically not said that grounds of arrest, my lord, required to be furnished to the accused in writing. Your lordship, I am just I may be wrong, my lord. I am trying to find out, my lord. Your lordship, I just like to point out conclusions, my lord. Therefore, in Bihan Kumar judgment, therefore we conclude the requirement of informing a person arrested of grounds of arrest is a mandatory requirement under, of article, I am, yes, agree, my lord, article 22(1). The information of the grounds of arrest, second, my lord, B. The information of the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the person effectively in the language which understand. Nowhere, my lord, it is mentioned that it is required to be furnished, my lord, by way of writing. And thereafter, my lord, before that, the judgment of Pankaj Bansal and my lord Probir Purkastha was discussed. And before, and my lord, Pankaj Bansal and Probir Purkastha, my lord, also mentioned one of the constitutional judgment, Kishan Agarwal, my lord. That Kishan Agarwal, if your lordship, that judgment is also available, your lordship, in that judgment, my lord, what happened at that point of time regarding preventive detention case, my lord. And preventive detention case and thereafter, my lord, arrest, my lord, later on by judgment, both 22(1) and 22(5) were equated. And now, my lord, in that thereafter, my lord, in that case, my lord, only because the preventive grounds of arrest were communicated, but not in the language in which, my lord, the accused person understands.
It
So,
cannot be communicated. It cannot be said to ground of arrest.
so what the
Only reference.
Mr.
and-
Khandekar, please sit down.
So on the basis of that, my lord, the court ultimately held that no, the accused person is required to furnish the grounds of arrest in Hindi. My lord, that is in the language in which he understands. So that is the issue, my lord. And that issue was, my lord, held by that issue was decided by the constitutional judgment of the Harikishan Agarwal. And thereafter, my lord, in one another constitutional bench judgment, which, my lord, Vijay Madan Lal Chaudhary, about that judgment, which judgment, my lord, I would just like to point out paragraph 22 of the, my lord, Ramkishore Arora. In Vijay Madan Lal Chaudhary.
Mr. Borthakur,
Yes,
let us do one thing. You try to find out how the other high courts dealt with the issue.
Yes, ma'am.
Because this issue is arising everywhere.
Yes, yes. Well, regarding the present case, however, my lord, prospective effect, my lord, regarding prospective effect, my lord, already, my lord, that has been decided by the Pankaj Bansal itself, my lord. So, my lord, my prayer before lordship.
No, that's all right. You see some
Yes.
other judgments of the High Court.
I will try to find out, my lord. Otherwise, my lord, in fact, my lord, I will
Let
also
us
try to,
fix the matter on Friday then.
I will also try
In the
to, my lord,
meantime, you try to find out some judgments of the other High Court.
and my lord, Bihan
And
Kumar
if
itself is
there
not.
is any judgment of the Supreme Court on this point.
Yes, my lord, I'll try to find. And Bihan Kumar itself is not applicable in case of NDPS cases, my lord. That is my argument, my lord. Because
No. It facts may be different, but the
arrest is
law
same.
is
if my
the
lord,
same.
if my lord, we are going to equate, my lord, about Article 21, then Article 14 violated, my lord. Although all these issues, my lord, I am not going to discuss because already Supreme Court has decided, because NDPS and other offenses can never be equal, my lord. So that's why, my lord, NDPS is a special act, my lord. Unequality is itself created by creating specific provision under Article 37, under Section 37 of the NDPS.
My
No,
submission.
in that decision in Bihan Kumar, it is observed by the Supreme Court that this statutory bar will not be
Yes, my lord.
applicable.
Yes.
Constitutional provision is first, my lord, then is to come. It cannot ever override the constitutional provision.
Because Constitution is the grand norm.
Yes, yes.
So if any law is contrary to the provision of the Constitution,
Yes. Otherwise, I am not going to always expect, but my lord, regarding
so
this.
let us do one thing. Let us fix it on
Next week, Thursday, my lord. Ultimately, on that day, my lord, everything.
no, coming Thursday.
Yes, my lord.
Coming Thursday.
Yes, my lord. No, not coming Thursday, my lord, next Thursday.
No, my lord will not.
It
may
will
not
be
be
too
there.
long.
On Tuesday, my lord, next Tuesday.
Not Tuesday. This week.
Monday, my lord.
Monday, this court will not be sitting. I will cancel it.
Friday, my lord.
Friday, my lord.
Since
Friday.
long.
Friday.
Okay. Third in part,
My lord, Friday at 2, my lord.
list the matter on Friday. Mr. Khandekar and also Mr. Borthakur for additional PP for the status.
Yes.
All the matters, other matters also.
5 and 6.
I think case number is same, but my friend is different.
5, 6, 25, 26.
So, Mr. Das, in all these matters, the issue is same.
My lord.
So,
Well,
to
basic,
deal with this
Yes.
issue, whether the judgment of Bihan Kumar will be
Yes.
applicable
yes.
prospectively or
Yes, so that
retrospectively.
issue is there regarding the writing part.
Hmm?
Writing part, my lord, the communication in writing, that part we will have to examine, your lordship will examine as to whether it has a prospective effect or not. But regarding oral communication, my lord, on merit, my lord, on the record, if your lordship will examine this, my lord, probably, my lord, they did not even communicate the grounds of arrest orally also in these cases, my lord, all these cases. So that part is there. But regarding this issue on law, as to whether the judgments of Bihan Kumar or Prabir Purkast or Pankaj Bansa, apart from Pankaj Bansa, has retrospective effect or prospective effect, that issue can be kept open, my lord, that we can submit on that matter.
Not that is so.
Yes.
But I have advised Mr. Bortakur try to find out some.
Sir,
decisions
I
of
have
other
come
high-
across some judgments of the other high courts as well, my lord.
Yes.
Hello, otherwise I am not disputing any of the constitutional provision that has been decided by the Supreme Court. But one of my argument is that, my lord,
17, 18, 19.
No, whether this court has dealt with that issue.
Yes, yes,
perspective.
yes.
Which paragraph?
Paragraph, my lord, it's, that is the discussion part. 16, my lord, from 16.
So here the court tried to distinguish the decision.
Yes.
Furnish a copy to Mr. Bortakur.
My lord,
yes,
my lord,
Let him go through it.
my lord.
otherwise, my lord, regarding furnishing of written grounds of arrest, yes, right now, my lord, it will be, but I would like to, my lord, I place one argument that while that, my lord,
No,
about-
not today, Friday.
yes, on Friday.
Right.
You go through the decision, yes,
My lord.
this is in respect of NDPS matter or IPC matter or PNS.
My lord,
IPC matter,
IPC.
302-201.
yes. Yes, 302. IPC.
Exactly not dealt with the issue,
My lord.
which is the issue before this court now.
My lord, yes, my lord, I think, my lord, in this matter, my lord, the honorable court, my lord, tried to distinguish the reasoning part from the operative portion of Pankaj Bansal. Pankaj Bansal, my lord, is only limited to section 19 of the PML Act. That is why, my lord, in that judgment, my lord, the court said that henceforth, in all such arrests which were made
under section 19 of the PMLA Act, the grounds of arrest will have to be furnished in writing. But the reasoning part, that is from Article 20 to 1, that part, my lord, was, my lord, borrowed in other judgments. Vihan Kumar and Prabir Purkar. So Prabir Purkar, my lord, was dealing with 43 UAPA as well as other offences, my lord. So unless and until there is a clear, my lord, direction that it is a prospective effect, we cannot say that, we cannot assume that, my lord, it has a, my lord, only prospective and it has no retrospective effect, my lord, regarding Prabir Purkar and Vihan Kumar. And that has also been discussed in other judgments, my lord, in Kanishka Singh's judgment, my lord, where the Honorable Supreme Court categorically said that, my lord, all the judgments of the Supreme Court shall have a retrospective effect unless and until it is specifically mentioned that it will have a prospective effect, my lord. And there is also another judgment in Lily Thomas, my lord, in 2000, my lord. There also, my lord, has dealt with this issue, my lord. My lord, I am only on this aspect that whether.
Lily Thomas is of different point, that is on
Yes,
review.
yes, but still, my lord, that part, my lord. My lord, I am only on this, my lord, whether a constitutional provision and interpretation of a constitutional provision can be said to have a prospective operation or can be said to have a operation from a future date. My lord will kindly see Lily Thomas judgment, my lord, for a moment.
No, not necessary
Yes,
today.
my lord.
Let it be on Friday.
My lord.
So Borthakur plays a role for all these decisions.
Yes, yes, yes.
Okay,
25, 26.
Change all the matters.
Item number 26.
All the matters.
Lordship, I am seeking bail on different ground, Lordship. Not this
What
ground.
ground?
Lordship, three accused persons are there, Lordship. Two has already been granted bail, Lordship. On the ground of, Lordship, prolonged incarceration, Lordship.
Under section? Arrested on the
22C,
ground?
Lordship. 22C, Lordship.
22C.
Yes, Lordship. The petitioner is the
So
driver.
how long you are behind the bar?
3 years, 2 months, 1 day. I have
3
annexed
years?
both the orders of the co-accused
At
persons.
what says the trial is pending?
My lord.
At what says the trial is pending?
Lordship, as of now, Lordship, 3 witnesses have been examined. Last witness was examined on 12/4/2024. Thereafter, nothing. This honorable court granted bail to 2 accused persons, Lordship, on 13/3/2025, and Lordship, another on Lordship, December 2024.
Earlier, your lordship has rejected
Yes,
twice,
Lordship.
twice, my lord. Third bill application.
This is third bail application.
Third bill.
Third bail.
Regarding long incarceration, also your lordship has earlier.
Yes, Borthakur, what is your submission?
My lord, considering all these aspects, my lord, regarding long incarceration, also your lordship has earlier, my lord, while rejecting the bail application. At that point of time also, my lord, last your lordship has rejected on 6/12/24, my lord. And now the
No, his ground is that 2 other persons have already been
Yes,
held
yes.
on bail,
no, but
arrested in the same.
Same forwarding, Lordship. Even the petitioner was the driver, Lordship. Driver of both these 2 persons, Lordship.
But the question is whether penalty is applicable in case of
No, my lord, Tarun
bail
Kumar-
matters.
he cannot be a ground, my lord.
I am seeking bail, Lordship, on the basis of long incarceration, Lordship. That point was considered in respect of 2
See,
other persons.
Mr. Ahmed, long incarceration, your argument was earlier dealt with by this court.
That was, Lordship.
Why
on-
that was not considered?
That was on Lordship 6/12/2024, Lordship. It was 5 months back, Lordship. As of now, Lordship, the stage of the trial is same, Lordship.
How many witnesses have been examined till date?
3, Lordship.
Huh?
3.
How many witnesses have been cited in the search sheet?
11, Lordship.
11.
Yes, Lordship.
Whether the record is available?
LCR are there, Lordship.
LCR
As per the cause list, Lordship.
What Thakur, have you gone for the
Today I have not. gone-
LCR?
No, my lord, today I have not gone through the LCR.
Yeah, that of this one. 19.5.
Page number 116, His Lordship, the order of the co-equus Lordship, Rubel Ahmed Bognia.
You go through the record.
Lordship, with folded hand, Lordship, alternatively.
Friday.
Yes, Lordship, may I pray that Lordship may kindly allow me to withdraw this petition then, Lordship.
You want to withdraw?
Yes.
All right. Mr. Ahmed, learned counsel for the petitioner, submits that he may be allowed to withdraw this petition. Prayer is accordingly allowed. This bail application is not a disposal on withdraw.
Highly applies.